Nobody appears. So wait, please. Are you there?
I am there for the respondents.
They are seeking adjournment.
Yes.
Have they informed you?
Yes.
You are seeking adjournment?
I'm not there in this case, but since the state seems to be going underrepresented.
Sorry?
I'm not there in this case. If your
Then
lordship-
please don't appear when you can't answer the question.
My lord, they tell me
Nobody
that.
is.
Your
They
lordship
never
pass-
sought adjournment.
No, they say that.
We are ready.
Your lordship, I pass it over for one case. I just call somebody. If you're the subject, I know it's the first case. Then
So
sir.
there, you have circulated a
Then you- my
for
lord,
adjournment, but I do not know when you want to do it. So you ask them when do you want to do it.
my lord, just one
I
case.
had a talk with the telephonic talk. They said next week any day.
Okay.
Except Monday any day.
No, let them come and submit because next day I will not adjourn it.
So we were thoroughly ready, but today
No,
morning.
we are. See, anybody can have problems.
Yes, no doubt.
But let them come and give a date. When do they want it?
One case, your lordship. I just one.
No problem.
Only lordship may take on Monday and all.
No, whatever. When the case is called out after 5-10 minutes, you just be here. We will have a consent date.
From supplementary list item 5, WPC 3550 of 2020.
इस केस में सर उन्होंने टेकन इंस्ट्रक्शन सॉल्व की वर्जन ले चुके हैं उसमें उनका दो चीज़ था एक चीज़ उनका था कि वो 4 months मांग रहे थे 4 months खाली करने के लिए जॉब खाली करने के लिए और दूसरा था कि 1 साल के अंदर वो जगह ऐसा क्या हुआ है ना कि वो सब कुछ हो गया प्रोसेस और लिटिगेट कर दिया गया मैटर ऑफ इंटेंस दलित तो 4 साल से पड़ा था तो ऐसा हो कि वो डेट जब क्रॉस करे तो कंटेम्प्ट
उन्होंने तो बोला ही था कि 1 साल में हम लोग
ठीक
करेंगे।
है कि वो हम उसको
अगर मान लीजिए कि कुछ जरूरत होगी तो एक्सटेंशन ऑफ टाइम फाइल करेंगे।
वो भी कोई प्रॉब्लम नहीं है जो बहुत ज्यादा नहीं होना चाहिए बस ये
नहीं, कुछ
और तीसरा जो एक करना है कि म्युनिसिपल कॉर्पोरेशन जो प्रोसेस शुरू होगा उसको एक्सपेडाइट कर दे टाइमली म्युनिसिपल कॉर्पोरेशन ताकि वो प्रोसेस पूरा हो जाए तो फिर इनका बस इतना ही
देखिए जो प्रोसेस में जो टाइम लगेगा उसमें हम लोग क्या ही बोलेंगे लेकिन
कोई-
जब 1 साल का टाइम रहेगा
हाँ, ठीक है,
इसमें
ठीक है,
तो
कुछ-
नेचुरली इट इज एक्सपेक्टेड म्युनिसिपल
हाँ,
यू आर
हाँ।
फॉर द म्युनिसिपल कॉर्पोरेशन यू आर फॉर द प्राइवेट पार्टी
एंड प्राइवेट
प्राइवेट
बस इतना ही प्रॉब्लम
you need 4 months time to vacate.
4 months
Okay. WPC number 3550 of 20. The learned counsel for the parties are present. Petitioner and private respondent are present. Nobody appears on behalf of respondent number. Respondent number. Are you there?
I'm for the state, your lord.
The learned counsel for the state is also present. Nobody appears on behalf of respondent number 5. This writ petition has been filed for the following. The learned counsel for the private respondent. हाँ sure. अपना appearance memo.
That I am appearing for the
You are appearing for the
Madhupur Nagar Parishad. Respondent
Nagar
5.
Parishad. अच्छा इनका भी appearance record. They need 4 months time to vacate. Order dated 28/10/2024 has been referred to by the learned counsel appearing on behalf of the private respondent to submit that the respondent landlord sought adjournment to seek instruction as to whether the petitioners would be given any space in the shopping complex which is proposed to be constructed by the respondent landlord after demolishing the structure. He submits that pursuant to such order, an affidavit has been filed which is dated 11/11/2024, wherein the private respondent has stated that all the petitioners will be given preference in the allocation of shop in the newly constructed shopping complex, subject to payment of rent and security amount as per prevailing market rate. Paragraph 5 of the aforesaid affidavit is quoted as under. The learned counsel for the petitioners, on instructions, has submitted that the petitioners would require 4 months' time to vacate the premises, and it may also be observed that the respondent landlord should take appropriate steps for construction of the shopping complex, and the authorities of the municipality,
Respondent number 5.
respondent number 5, shall also cooperate such that the petitioners are ultimately allocated the shops to run their livelihood. The learned counsel appearing on behalf of the municipality as well as the private
Nagar
respondents,
Parishad.
Nagar Parishad, as well as the private respondents, have submitted that the shopping complex will be constructed expeditiously, and there may not be any reason for the municipality to create unnecessary hindrance in the matter of sanction of map, etc. However, the municipality has to follow the procedure of law. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that the cause of action arose to move this court when a decision was taken to demolish the complex being in dilapidated condition. In view of the aforesaid submissions, this court is of the considered view that there is no need to keep this matter pending. The petitioners have already undertaken before this court to vacate the premises within a period of 4 months.
Private respondent.
Petitioners within a period of 4 months, and the respondents have also undertaken before this court to construct the shopping complex and give preference in the matter of allocation to the newly constructed shopping complex subject to payment of rent and security as per the prevailing market rates. In view of the aforesaid undertaking, the district petition is disposed of as such. ठीक?
1 year
अच्छा, it is expected that the needful will be done by the respondents within a period of 1 year. In case of any legal impediment, they may approach this court for extension of time.
After the vacating of shop 1 year.
1 year after the vacating of the shop. If the petitioners do not vacate the shop within a period of 4 months from today, it will be open to the respondents to take appropriate steps.
How well?
Much.
Pass over.
Pass
When
over.
do you want? 19.
20th is holiday.
21st will be good. Learned counsel for the parties are present. Give your appearances. An advance notice seeking adjournment in this matter has been circulated by the petitioner. Considering this aspect of the matter, and at the request and with the consent of the learned counsel for the parties, let this matter be posted for final disposal on 21st of November 2024 to be taken up at 2:15 as the first case.
From supplementary list for orders item 2 WPC 2954 of 2021 along with item 3.
May please your lordship. There are two cases, my lord. The item number 2 and 3. Both the cases, my lord, were listed on 12. And my lord has been pleased to pass an order, my lord, for listing both the cases on 19th in the supplementary list.
आज क्या?
But inadvertently, my lord,
19th का?
order was passed, my lord, in presence of both the parties.
My senior had argued this matter, Ms. Swati Shani. She has instructed his my lord had directed to this matter on 19th.
Yes, lord.
At the request of the council for the parties, post this case on 19th of November 2024.
Lordship.
They are for final disposal.
Lordship, final.
For they are for final disposal? No.
Yes, today it has come under the heading of
Orders.
orders. My lord said
Why for orders?
my lord said heard the matter at 10th. My senior
I
had-
remember.
It
Can
may
it
my
be
lord,
disposed of today?
Lordship, today, lordship. I am in difficulty, my lord, because I have to
You
file.
see, we have to.
I have to file wakalatnama, lordship. Therefore.
It was to be posted on 19th.
19.
Yes, we are on Tuesday.
Arey boy. Take your breath. Don't worry.
19th, lordship. 19th.
Okay. On 19th for final disposal.
Lordship.
But you must have heard the summation.
Yes, yes.
This has to be referred to.
Yes, yes. I'll go through it, lordship.
Item 4 contains list 79 of
There is
2021.
one case, my lord, in the daily for release, my lord. Item number 4, lordship, under the heading for admission. I pray, my lord, only 1 week time, lordship.
I don't
Because
know how do you
I have
mention a
to-
case like
I have
this.
to, I have to file reply, lordship.
No, we have to, unless the case is taken up, we don't adjourn matters. Yes, petitioner, who is there?
The order has been complied. We have revised their pay scale, and
But you have not made the payment, have you?
payments are to be made by the university leadership. We have revised the pay scale, forwarded to the university.
Who
Funds
is
have
for the
also.
university?
यूनिवर्सिटी है रांची यूनिवर्सिटी
When will you make the payment?
लेटर हमको कोई नहीं मिला है
Counter मिला है?
Letter
इनका affidavit नहीं मिला है?
letter is annexed with the show cause leadership, which is annexed in
रांची यूनिवर्सिटी
page 11.
रांची यूनिवर्सिटी को सपोज नहीं
Copy नहीं देते हैं? What is this?
I'll have to verify if it was served upon you. But we have passed the order. Leadership may kindly see page 11 of my show cause.
Counsel for the, nobody appears on behalf of the petitioner. Counsel for the opposite party state is present. He has submitted that needful has already been done on behalf of the state. Now it is for the university to calculate the amount
Yes.
and make payment to the petitioner,
Yes, yes, Leadership.
to the petitioners.
Yes.
To the petitioners. A copy of the order is annexed along with the show cause.
Yes.
He has submitted that the amount has already been disbursed to the university for payment. Counsel for the university prays for time to seek instructions and file an affidavit after remitting the amount. आपको कुछ नहीं करना
नहीं,
है?
कुछ नहीं।
After remitting the amount to the petitioners.
सपोज खाली देना
आप दे
And
सकते
I'll do it today.
हैं। तो आपको remit करके affidavit file करना है। ये नहीं कि करने वाले हैं,
नहीं नहीं
ऐसा affidavit मत करिए। ठीक है?
हम्म।
नहीं तो रजिस्ट्रार को बोलेंगे चेक लेके यही बनाने। ठीक है?
आफ्टर 2 वीक
हाँ, post on 4th of December 24 in the supplementary clause list.
Right.
Item 6 WPC 1712 of 2021.
Petitioner, yes,
The matter was listed on the 11th of November, and
On that day, the housing board has said that they will be giving us the possession of the plot.
No, there was some encroachment over the plot finance. We have stated that we allot the same plot to them. Removing the encroachment, only the local administration may be given direction to remove this.
You have to approach the local administration.
It's the state is also.
It is under whose encroachment?
And that's the report which has come from there is that there are riots, certain riots. Their encroachment as well.
So you will have to initiate a proceeding.
We will manage.
So why a state? You initiate a proceeding. You file PPLE case. You get that? It's your property. अभी आया है 2 दिन पहले सुप्रीम कोर्ट का जजमेंट ऐसा नहीं कर सकते. You have to evict them, but you undertake to take appropriate steps for the purposes of eviction and handing over the property. The learned counsel for the parties are present. The learned counsel appearing on this petition has been filed for the following reason. The learned counsel for the respondent housing board has submitted that the property which was allocated to the petitioner was
Plot number 91.
plot number 99.
L91.
L91.
कहाँ लिखें? Exact आना चाहिए.
In prayer.
Plot number L91. Where is it located?
But
Situated in
Bharat.
residential colony of housing board, Camp Hazaribagh.
Para
So,
Local
Camp Hazaribagh क्यों लिखा है? Para 1 में.
That's in my
That
counter
was-
affidavit. There is the allotment letter on it. It should see. Page 11.
Allotment letter is in annexure to that is.
Plot
page
number
33.
91, while allotment letter number 764/A dated 78 लिखते हैं.
8. This is dated 8/5/2010.
8/5/2010. लिखा है आपका डॉक्यूमेंट टैली नहीं कर रहा है. Annexure C para 11.
The ladyship may kindly see the annexure 2 of the writ petition at page number 33. That is the allotment.
You see, your statement in para 11 is not matching with your Annexure C.
There are 2 letters. One is of 8/5 and second is of 3/12/2010.
One is 8/5. Where is 8/5? You have annexed 8/5. Annexure 3.
8/5/2010, annexure 3, page 34 to 37.
White letter dated 8/5/2010 as contained in Annexure 3. She submits that since the property is under encroachment of third party, the housing board is willing to take all steps to get the property vacated and hand it over to the petitioner. But there is no question of any allotment of any alternative plot. She has also submitted that as per the counter affidavit, the property was in fact handed over to the petitioner, correct?
Yes, sir, taken the possession.
And taken possession, but for one or the other reason, the physical possession of the property is not with the petitioner, correct?
Yes, sir.
She has also submitted that appropriate order be passed so that the state also cooperate with the housing board.
Yes, sir, some due also which they are required to pay.
Sorry?
Some due amount is also there which they are required to pay.
15 to 30,000 in the case. The basic
This is
is
what will be calculated.
To the state, we also directed to cooperate so that the grievance of the petitioner is ultimately redressed. She has also submitted that there are certain dues which are payable by the petitioner. The same will also be computed and handed over to the petitioner, and the computation chart will be handed over to the petitioner so that the petitioner pays the amount before taking possession. After hearing the learned counsel for the parties and considering the nature of grievance, this court finds that the respondent housing board has submitted that plot number
L90.
L91 that have submitted that they will take appropriate steps for evicting plot number L91 from the enclosures and hand it over to the petitioner. This court is not inclined to proceed any further in this petition. It is the housing board is directed to take appropriate steps for the purposes of taking physical possession of the property in accordance with it. The authorities of the state are also directed to cooperate in the matter. It is further directed that the who will give the calculation, who will forward the calculation?
It will be forwarded through the secretary.
The respondent number 2 is also directed to give the dues, give the calculation of the dues which is due and payable by the petitioner. The needful be done by the respondent number 2 by forwarding the calculation sheet to the petitioner through speed post at the यही आपका address है?
Yes, sir.
At the address of the petitioner which has been provided in the petition itself. The petitioner would be liable to so that the petitioner may clear the dues in accordance with them. क्या पता dispute करेंगे or not. In view of the aforesaid facts and circumstances, in view of the aforesaid, this petition is disposed of as.
You reduce one clear reduce that time may be fixed. Time may be fixed for the
They will take immediate step. Time क्या देंगे?
a time of 4 months or 6 months as you reduce basis.
Just say
Maybe
देंगे. There are third parties staying over the property. They may claim title. You do not know. हो सकता है ना?
Yes.
Yeah. So कुछ नहीं कर सकते.
And it's in fact the commercial
Appearance
petitioner is also staying there only.
Could be. If he is there, it could be happening.
Attempt 7, contempt civil 594 of
Expeditious
25.
step.
This matter the police stand to file the reply to the first file by the party number.
What reply? You don't need any. They have done it.
No,
That's
no,
it.
no, the matter is
No means what?
Yes, kindly see annexure 8, page 11.
We can't go on like this,
No,
right?
so the so-called filed by the opposite party is self-contradictory to the counter affidavit filed by the opposite party. Kindly see page number 11 of annexure A, Lordship.
Yes. What is it?
राजस्व कागजातों एवं भौतिक सत्यापन तथा नापी में पाया गया कि प्लॉट संख्या 29/23/25 पर पार्क नहीं बल्कि कई घर निर्मित है. Now can you see the counter affidavit?
देखिए इतना कॉन्ट्रडिक्शन है, टाइटल सूट नहीं चल रहा
नहीं,
है. आपके पास गए थे स्पॉट पर?
हाँ,
Yes or no? Were you there?
हाँ,
That is sufficient.
बस देख ले जाओ जो एक चीज दिखा रहा है.
देखिए ये कंटेंट है ना. हाँ तो
नहीं तो
कंटेंट
सर-
में कोर्ट का सेटिस्फैक्शन. एक बार गए, आपके सामने जो हुआ, because whatever they have done on the spot is not going to create any right, title, interest or possession in connection with the
उसके लिए
property.
हमने बोला यहाँ पर बस एक चीज देख उसमें काउंटर एफिडेविट सेल्फ कंट्रैक्ट उसमें बोल रहे स्थानीय जांच के क्रम में ज्ञात हुआ कि प्रश्नगत भूमि पर पार्क बना हुआ है. सीओ बोले एक जगह बोल रहे पार्क बना हुआ, दूसरी जगह पर अभी बोल रहे कोई पार्क नहीं है, वहाँ पर घर बना हुआ है. सो द स्टेटमेंट मेड बाय द सीओ इज सेल्फ कंट्रैक्ट.
आपका एनेक्शन से नहीं चलेगा ना, आपका इससे चलेगा.
नहीं, इनका
एफिडेविट में जो इन्होंने लिखा है
इन्हीं का हम अपना कुछ नहीं लिख रहे
नहीं
हैं.
नहीं इनका
इन्हीं का काउंटर एफिडेविट देख लिया जाए, पेज 11 देख लिया जाओ. एनेक्शन है.
कौन सा प्लॉट में, कौन सा किस में बना हुआ है पार्क? प्लॉट नंबर
29-23 और 29-25 में.
हाँ.
इसमें बोल रहे हैं कि प्रश्न भूमि पर पार्क बना हुआ है.
हाँ.
और यहाँ पर देख लिया जाओ जो अभी जो फाइल किए हैं एनेक्शन ए पेज 11.
हाँ.
रिप्लाई राजस्व कागजात एवं सत्यापन भौतिक सत्यापन नाप में पाया गया प्लॉट संख्या 29/29/25 पर पार्क नहीं बल्कि घर निर्मित. दोनों जगह सीओ.
This confusion was created only by the petitioner, Manos. He is claiming that this park is my land, and he has.
We will go by the averments made in the show cause. We will not go by whatever they have annexed, right?
Yes, अब उसी पर हम भी रिलाय कर रहे हैं. Because so far.
Did you take compensation?
No. So far as plot number 29, 23, and 24, no compensation was given to the petitioner.
Not to the ancestors of the petitioner. Compensation has been paid, Manos.
Contempt case, civil number 594 of 2023. A show cause has been filed. Counsel for the parties are present. A show cause has been filed on behalf of the opposite party, wherein a specific statement has been made in paragraph 8 that in presence of that the demarcation was done on 21/10/24 in presence of the petitioner, and during demarcation of land it was found that there is no park situated on plot number 2923 and 2925. Rather, many houses are built on those plots. And it was also found that park is situated on plot number 2939, 2940, 2941, 2942 and 2938. It has also been stated that so far as plot number 2923 and 2925 are concerned, the same were subject matter of acquisition in LA case number 2 of 1961-62. And Chattu Mehto, who is the ancestor of the petitioner, has already been paid compensation amounting to rupees 15,741.89 on 25/8/1962. Paragraph 8 of the show cause is quoted as under. The learned counsel for the petitioner has submitted that though the so-called demarcation was done in presence of the petitioner, but there is mismatch in connection with the report annexed with the show cause and the averments made in paragraph 8. Considering the aforesaid facts and circumstances, this court is of the considered view that the demarcation having been done on 21/10/2024, the court is not inclined to proceed any further in this contempt petition. The law is well settled that the demarcation there can be no doubt that so-called demarcation does not extinguish or create any right, title, interest or possession in favor of one or the other party. If the petitioners ask, petitioner है कि petitioners?
Petitioner.
If the petitioner is still aggrieved, it will certainly be open to the petitioner to have his remedy as may be permissible under law. Contempt of.
Item 8, Contempt Civil 745 of 2023.
Sorry?
Order is compliant.
Where is the notification? Give it to him. It's a Contempt Civil 745 of 2023. Counsel for the parties are present. A copy of notification, Gazette notification dated 11th of June 2024. It is in Hindi. What is the name of this? You have filed show cause also? Namely, what is the name of this
Resolution.
resolution?
Sample dated so was published in the Gazette on 28th October.
Resolution dated? It's not here.
11th
Where
June
is the show cause? When did you file it?
Sorry. This was not final. Is it
Show me please. What name should I write?
resolution dated 11th June 2024.
Namely,
They published on 28th October 2024. That विषय में राज्य ग्रामीण विकास रांची का नाम राज्य ग्रामीण विकास एवं पंचायती राज संस्थान रांची करने सत्ता
all
प्रदान
right.
करने
Regarding framing of rules to govern SIRT, SIARD, Jharkhand, right? He submits that the order passed by this court has been complied. Considering the submissions, the order passed by this court having been complied, this court is not inclined to proceed any further in this petition. The contempt petition is accordingly filed. अपना पेरेंट्स जो विद का ऑर्डर था ना उसी में लिखा हुआ है सर झारखंड.
Item 9, Contempt Civil 821 of 2023.
Yes, petitioner.
The order has not been complied with. I have recently been instructed by GC to appear in this matter. I was doing that as per the instructions which I have received, the GC will be preparing an LBA against the order. I was doing that 4
When
weeks.
did you file your LPA?
It has not been filed. So
After
it will be filed.
more than 1 year has been elapsed, now he is telling that I am going to file LP. And in the same matter, my lord, one part of the order is dismissed by the Supreme Court also, their SLP, and that has been implemented.
There were 2 sets of employees leadership.
Same 28 employees.
When will you
44.
file your LPA?
It's in the coming week we will be filing leadership. And 4 weeks time will be granted. Either we will be, either we will obtain a stay
You
order
are going
or
to
not.
file it in the
Yes.
coming week?
Yes, yes.
I'll post it in the coming week. You give the LT at least the number,
Yes, yes. I
so
will-
that I will adjourn thereafter for at least 4 weeks.
I will.
Contempt Civil 821 of 2023. Mr. नाम बताएं? Sushant Kumar has submitted that he has received instructions on behalf of opposite party number 1 to appear in the present case, and he has been instructed that ATC has taken a decision to file appeal against the order involved in the present case. The appeal is likely to be filed by the next week. The counsel for the petitioner has, and prays for adjournment. The counsel for the petitioner has opposed the prayer and has submitted that the order was passed way back as on 17/5/2023. However, considering the aforesaid submissions, pose this case on next Friday in the supplementary cause list. The opposite party to furnish the detail regarding the LPA.
Item 10, Contempt Civil 504 of 2024.
Yes.
My lordship, party complaint. Duty has been allowed, my lordship. Continuity service has been also passed the decision order, my lordship. But 50% package is not paid, my lordship.
Why have you not
Yes, we
paid?
kindly have the show cause, madam. We have filed the show cause, annexure A, page 9. We
You
have
have paid?
Yes, madam. That Sri Hari will be paid 50% tax.
Will be paid.
Will be paid, my lordship.
Pay करके आइए.
और उसमें kindly give us
Credit करके आइए.
और उसमें 4 weeks में भी give
4 weeks.
और I'll
4
comply with
days.
this. और sir weeks time में भी given.
You are already in contempt.
और sir I'm humbly playing, madam. Just a
No,
weeks time
no,
में भी
no.
given, madam. Will be compliant.
By Friday, you file a compliance report by remitting the account in there.
और next week's time में भी given. By next week we will be filing this. A week's time, madam.
I'll give you weeks time. Next Friday, I'm posting it.
Madam.
And you have to file your compliance report. We will not, we don't want that you are going to pay.
Madam, we will be filing compliance.
They should see the color of money. At least the SMS.
Madam, I will be filing this.
My lordship, my representation is filed in the month of May, my lordship. Duty has been given after 5 months.
तो क्या करें?
डिले हो गया जो आपको ड्यूटी के लिए था, हैंड टू माउथ है जो आपको.
आपको पैसा देने. Contempt Civil 504 of 2024. Counsel for the parties are present. Counsel for the opposite party prays for time to file a supplementary show cause after crediting the admissible amount payable to the petitioner in their bank account. The details of such credit should be mentioned in the show cause. Post on next Friday in supplementary cause.
Item 11, Contempt Civil 807 of 2024.
Contempt Civil 807 of 2024. Counsel for the party are present. Counsel for the petitioner submits that order passed by this court has been complied, though belatedly. Considering the submissions, this court is not inclined to proceed any further in this contempt petition. Accordingly, the contempt proceedings are hereby.
Item 12, WPL 4593 of 2024.
After responding of 5 and 6, I have filed an IA for vacating the stay. IA number 11605.
You have filed your counter.
First I filed IA.
You filed your, you decided. What's the big deal about it?
Leadership actually the petition contains all the documents annexures.
You
on
don't
which
want
I
to
have
file a
relied.
counter affidavit.
Yes, I will file. Then I will.
You are filing
Actually,
stay vacating instead
that
of filing a
appeal
counter
was-
affidavit and getting the matter disposed of finally.
Actually, for listing IA was necessary that I
Who
have filed
says
an
so?
IA.
Listing is your right. All mentionings are allowed by default.
I will file in counter.
They want to file a counter affidavit.
Yes,
They are keeping it IA, this IA pending. You also file your rejoinder. We'll fix a date.
Yes.
The learned counsel for the parties are present. IA number 11605 of 2024 has been filed seeking vacation of interim stay. The learned counsel for the
Respond number 5 and 6.
however, counter affidavit has not been filed by respondent number 5 and 6, so that the matter itself could be disposed of. At this, counsel for the respondent number 5 and 6, आपका कोई role है? Praise for how much time? 1 week should be sufficient.
Yes.
Praise for and is granted Time till 22nd November
Okay.
to file the counter affidavit. Rejoinder if any by 29 November. State का counter चाहिए sir? I'm asking you.
No, Your Lordship, they have appeared. If they want to file, they can file. If not, still the matter can be heard. Finally.
No. If they have nothing to say, then what do you think? If so advised, the state may also file the counter affidavit. If so advised, if you want to file, you file it. Post for final disposal on
टाइम थोड़ा दो वीक
हम ज़्यादा ही दे रहे हैं हम 10 तारीख को रखते हैं 10 दिसंबर को रखते हैं post this case for final disposal of 10th of December 24 the parties to file short synopsis and the judgments and the provisions of law which they seek to rely upon by 6th of December ये ट्रेड यूनियन का मैटर है थोड़ा सा अच्छे से सारा we have not decided much matter on trade union, so you assist us on the point of on the provisions of law and the judgments also. What is it that you are fighting for?
Two factions of the same trade union are fighting. One faction has got the trade union registered by their representation. I am agreed, and registrar has allowed his application, rejected my application. So against that order, I preferred a writ application before this honorable court. At the time of hearing, liberty was granted to us to prefer an statutory appeal under Section 7 Trade Union Act before the Labour Court. That I have filed. Now they filed an application challenging the maintainability of that appeal before the Labour Court.
And that is the only order under challenge before this
That
court?
was dismissed. Against that order, the petitioner has come. That
RGA has been dismissed regarding maintainability. It has been dismissed.
It was
The appeal has not been decided.
Appeal is at the stage of final hearing. That is something that you do not accept. 1 or 2 days.
The only point Your Lordship will please consider, this case has been filed by the Bokaro Steel Workers Union. Whether this is maintainable, he is saying that Bokaro Steel Workers Union should be registered as a trade union. And now he has filed an application on basis, by stating Bokaro Steel Workers Union.
Are they a party? Are they party in the appeal? If anybody is party in the appeal,
They have filed an appeal.
I have filed.
You have filed your appeal.
Yes, Your
I have
Lord.
filed appeal. Against the order of the
Just a
registrar.
moment. It is an appeal, right? You are the respondent in the appeal. Now you have challenged an order passed in the appeal. Now you are objecting to their appearance before this court.
Maintainability. Whether they can file a case on basis of Bokaro Steel Workers Union.
This was the objection raised by you.
Yes, Your Lordship. And on the ground that they are saying that it should be registered. Bokaro Steel Workers Union should be registered as a trade union, and they are filing an application on behalf of Bokaro Steel Workers Union. How can this be?
Let a Xerox copy of the records be called for from the concerned court. Trade union का कहानी ऐसे खत्म नहीं होता. फिर उस दिन हम record करेंगे, आधा document रहेगा नहीं रहेगा. We have to see the records.
Yes, Your Lordship.
We have to we get the record from which court?
Labour Court, Bokaro.
Labour court.
Yes.
Let this order be communicated. आप सुन लिए ना, ऐसा नहीं है कि आपका कोई say नहीं है. You better file your counter affidavit. देखिए तो counsel for the state is also directed to seek instructions and file counter affidavit in this case. Trade union का matter में state का role तो होगा ही ना.
Ultimately, the order issued by the registrar is in dispute. That has been challenged.
Order has been passed by the state.
आपको पार्टी बनाया है ना?
जी.
आप भी काउंटर एफिडेविट फाइल करिए, लॉ पॉइंट पे फाइल करिए, चाहे कुछ भी पॉइंट पे. You see, in the case of union, it's a right of thousands of employees which is involved. They are just the face. It can't be lightly taken, right?
तो रिकॉर्ड जो लेटेस्ट मंगाई है वो हमारे थ्रू है
नहीं रिकॉर्ड तो यही से कोर्ट से है.
From daily list of fresh filing item 2, WPA 1455 of 2024.
WPA number 1455 of 2024. Let notice be issued to the respondent for which recusals be filed under speed post and also ordinary process by Monday. The Union of India is not a party. The order has been passed by Ministry of Labour and Employment. They are not a party. Let the petitioner let the Union of India through the Ministry of Labour and Employment Office of Deputy Chief Labour Commissioner within bracket C from Bhavan, New Colony, Dhanbad. We made respondent number 2 in this case. The insertion be carried out by the counsel for the petitioner in writing during the course of the day. The petitioner is directed to serve 2 copies of the petition in the office of Learned Additional Solicitor General of India. By Monday. Let a counter affidavit be filed by the newly added respondent. Also, post this case on seventeenth of December, awaiting service report, office to last week posting.
That's it.
Shan Kumar Singh, Nandi.
Man, the impugn over this state.
As in,
Why lots of off? Impugn over the other execution cases.
Sorry?
Execution cases.
Execution case. कौन सा execution case
इसको
का
execute
नंबर?
करने के लिए वहाँ पर
कहाँ है नंबर?
हमको I'm sorry.
नहीं है तो हम लोग कुछ नहीं कर सकते. क्या चीज stay करेंगे?
Lost.
For admission item 3,
10 in addition कर दीजिए. मान लीजिए कुछ ऐसा होता है तो आप आइए टाइप करके मेंशन करेंगे तो प्लीज लिस्ट ही हो जाए.
Lost.
10 in addition कर दीजिए. स्पीड पोस्ट है, ऑर्डिनरी प्रोसेस है, 10 in addition. Affidavit regarding service of notice to 10 we also filed them.
Okay.
उनको सर्व कर दीजिए. यूनियन ऑफ इंडिया को पार्टी नहीं बनाए, क्यों नहीं बनाए?
I'm sorry. We should.
स्टेट चाहिए, मिस्टेक हो गया.
हम बनाते हैं।
For admission attempt 3 WBC 2861 of 2015.
Yes, petitioner.
So, in this case, I am going to give time because this case will be argued by Mr. Rajiv Ranjan Tiwari and he is out of his district.
How is this matter listed? Was it a date fixed matter? नहीं कैसे ये मैटर लिस्ट में है?
Date is fixed.
Sorry?
Date is fixed.
Date.
It is last order. 12 September 2000.
Order or 12 September. Order dated 8/8/24 has been complied.
Once you receive the instructions, it's ready.
And you have to be silent. He is seeking time, you are
No,
silent.
my lords, I have submitted my lords. Just letting you submit. There, in a 4H proceeding, my lords, Jamabandi has been cancelled. And that is on that basis only the TC has decided his representation of my lords. They are stating that their land is not mentioned in that 4H proceeding, my lords, and they are stating that it is mentioned. The Khata number 30, it is mentioned in that order of 4H, and their land, the Jamabandi has also been cancelled.
When will you comply now?
That's
The Deputy Commissioner Hazaribagh is held responsible for compliance of the order. He is non-serious about it.
No, it's any day then. The
Any
next week,
day.
I'll take file it.
WPC number 2861 of 2015. Counsel for the parties are present. Counsel for the petitioner seeks adjournment. Counsel for the respondent also prays for time. Prays for and is granted time till 26 November to comply the order dated 12th of September 2020. Post on 28th of November.
Item 4 WBC 4996 of 2015 along with item 5.
In this matter, the state was directed to file on supplementary counter affidavit, which could not be filed. Required order dated 21st 10/20.
Why have you not filed it?
He is searching some document also.
Searching. बिना सर्च किए आप एफिडेविट में कुछ भी बोल देते हैं बिना देखे. How serious it can be?
Last chance may be given also for the 3 weeks.
किनसे आपकी बातचीत हो रही है? Whom are you contacting?
डीएससी से पहले बात हुई थी फाइल करने के लिए. उसके बाद आज इंस्ट्रक्शन हम लोग नहीं ले पाए. आ भी नहीं पाया काउंटर. हम लोग अगला 3 वीक्स में हम लोग फाइल करवा.
पहले काउंटर कौन फाइल किया?
डीएससी
डीएससी किए थे काउंटर. चेक करके बताइए. डीएससी एडवाइस.
Yes. In 4996
WPC number 4996 of 2015. Counsel for the parties are present. Counsel for the state prays for time to comply order dated 21/10/2024 and he submits that he has contacted the district education officer, district superintendent of education Ranchi, who is searching the records and therefore the order could not be complied. He prays for time. Time till 27 Time till 3rd of December is granted to comply the order dated 21/10/2024. Post on 5th of December. Let a copy of this order to be forwarded to the Secretary, Human Resources Development Department, Government of Jharkhand. MDI Bhavan kahan hai?
Now it would be School Education and Literacy Department. Earlier it was like that, the constitution of the department.
कोई बात नहीं, ये लास्ट सेंटेंस छोड़िए कि आप लोग अपना डिपार्टमेंट भी सही नहीं, 2015 का मैटर है, 3rd December तक कर दीजिए, पोस्ट ऑन 5th.
And in the meantime, we have filed a reply to their supplementary. If they respond to that or seek instruction on that also.
What have you stated in your?
We have stated that about so far as the functioning of the school is concerned, the objection raised by them about the requirement of land and all these things. We have already made a detailed representation annexing all the supporting documents. If they could seek instruction on that. It was made before the
वो फिर हम लोग डिस्पोजल करेंगे, डिस्पोजल ऑफ रिप्रेजेंटेशन.
It was before the directorate it was made.
Item 6, WPC 3/6 of 2016.
I pray Lordship 2 weeks time, Lord.
For what?
Time was granted earlier for filing reply, Lordship, but I could not file it within the stipulated time. 2 weeks further time, Lordship, by way of last interview.
WPC number 3/6 of 2016. Counsel for the parties are present. Counsel for the petitioner prays for and is granted time till 3rd of December to comply the order dated 22/10/2024 by way of last indulgence. If the order is not complied, the case will be taken up on the basis of the materials available on record. Post on 5th December.
Item 7, WPC 5826 of 2017.
Can you see the last order, 12th September? They have replied to my IM, in which I have proposed that I have challenged the order of the Deputy Commissioner by which they have restricted the sale of land belong to the petitioners. Petitioners or there are 3 petitioners, they are running a chit fund company. And in 2016, a police case was instituted and it was later on transferred to CBI as per the order of this Honorable Court in a PIL. CBI has also filed a counter affidavit in this case, my lord. My prayer in the IM, my lord, to allow me to sell the land through Deputy Commissioner. All the proceeds of the sale must go to the account created by. I want to repay the amount, my lord. I have already repaid 8 crores and odd, my lord, and as per me, 2 crores and odds is still due to the investors, my lord. That's why I gave proposal. CBI has also filed a reply in this case, my lord, on 28.
Have you filed your reply?
Lordship, since all the documents are with CBI, my lord, we have transferred the document to CBI, my lord.
You don't keep the record for yourself.
Lord, we keep the record, my lord, but I'm praying for further 4 weeks to reply to the IM, my lord, because all the records were sent to the CBI, my lord, so they have filed the counter, my lord, we'll also reply to the IM, my lord, further time I'm praying for.
Where is the reply of CBI?
Reply of the CBI is dated 27 March 2023. Relevant is page 6, internal page 6 of the reply, my lord. Before I was replying, my lord, the
CBI has said that it is still continuing with the investigation, and the amount misappropriated by the accused petitioner is yet to be calculated as the investigation against the society is still continuing.
How this property can be released for sale?
Now, my proposal is that Deputy Commissioner may be
Our
appointed as.
proposal se nahi hoga na.
That's why I give a proposal. My bona fide, my lord, I want to, the sale proceeds may go to the account of the Deputy Commissioner, my lord, and he may disburse.
There may be many other persons, we do not know how many persons are there. Can it be disbursed to whatever details you disclose? We do not know how many persons are there.
I am ready to cooperate. They have taken all my records with police and now CBI. CBI may be directed.
According to you, how much is the dispute? How much is the due?
I have given a statement in this petition, my lord, that I have paid all 8 crores and not to the investors, my lord, and as per me 2.3 crores is still due, which I have to pay to the investors, my lord. As per me 2.34 crores. But CBI may be directed, my lord, to fight what they have done in last 1.5 years, my lord. It's affidavit of 27th March 2023. If they have come with any finding, my lord,
What is the relief did you pay for?
I have really paid for, my lord, that the order, Annexure 2, my lord, the order by which, that is main petition page 52. Read petition page 52.
No, you just read your prayer. What is your prayer?
Prayer. For question the letter number 606 dated 16/3/2016 issued by the respondent
How,
number 3.
when a criminal case has been instituted, how this relief can be granted?
Investigation is still going from last 6 years. My only bona fide is that investors may be repaid, my lord. All
This relief will not be granted by this court.
my only place that CBI may be directed to file a further affidavit, my lord, what they have found.
Yeah, monitoring नहीं चलेगा CBI का.
I have filed an application from thus to show my bona fide that I am ready to pay, my lord. We have landed property in the district, my lord, that may be sold through Deputy Commissioner and proceeds may be distributed among the investors, my lord. That is my bona fide.
Landed property किसके नाम से?
All the 3 promoters, my lord, the President, Secretary and the Treasurer who are the petitioners before this lordship, not in this writ application.
It is in their name.
Yes, ma'am. That's why I pray that this properties
Who is stopping you from selling?
that letter, my lord, Annexure 2, my lord, may kindly see page 52. May I read, my lord? Yes.
Who is this person Namdhari? Bhagwan Singh Namdhari is a petitioner.
Yes, ma'am.
इतना आसान नहीं है इसमें थर्ड पार्टी फोर्थ पार्टी राइट क्रिएट हो गया.
I will not take a single rupee from the sale
No,
proceeds.
no, there is no question of taking our property, taking it. You have also executed a parallel power of attorney, and that power of attorney holder is selling the property.
No, that has been stopped in 2016 also.
We do not know whether you have sold or you have not sold any property.
There's still the landed property. I will file affidavit. Which are the landed property in the name of these 3 petitioners? My lord, I file affidavit in this court, my lord, for the lordship satisfaction, which are still in the name of these petitioners, my lord. The district registration authority may very well comment upon that, whether that property belongs still to me or whether they have sold out to any other person through power attorney or not. That is only my bona fide, my lord. I am ready to face these criminal consequences in the CBI case, my lord. I am not shying away from that.
Where is the counsel for CBI?
I will inform you.
Call him
At
here.
12:30. Obliged.
Who was appearing?
I remember Sri Anil Kumar.
Call.
Item 8, WPC 957 of 2018.
In terms of the last order, the above forest has filed a supplementary counter affidavit day before yesterday, to which we need to file our response.
What stand have they taken?
No, Your Worship, pursuant to order date 12/9/24, a report was to be prepared regarding the waste materials that we have brought on record, and that was to be on record, Your Worship, in which we have made some suggestion in paragraph 4 that something has been done by the petitioner, and some more thing we have suggested with the conclusion of the report in paragraph 4.
In view of the fact that waste
Yes.
material has acquired the nature of raw material.
Yes, Your Worship.
It must be requiring environmental clearance.
Yes.
Have you got that?
Melody,
Because these are all environmental law. You
Madam.
need environmental clearance. Do you have environmental clearance?
for that I will have to take instruction, my lord, since it's a case of 2018, my lord. and-
कोई भी आपको कुछ भी लिख के दे देगा, रिपोर्ट दे देगा, उससे कुछ होने वाला नहीं है. Unless you have environmental clearance, you cannot operate a unit.
Our stand has been that we have been developing the surrounding area as a green belt, my lord, which has been acknowledged that it has been being developed so much. And in view of the fact that all those waste materials have acquired the nature of raw materials, so the
What is the nature of raw material? What is the nature of waste material? Plastic? Organic waste तो नहीं मिलेगा आपको.
Coal, dumping of waste coal, my lord.
Waste coal.
Char and dolo char.
Char and
that
dolo.
is the raw material for sponge iron.
Sponge.
It is not plastic material.
No.
In order to execute this work, do you need an environment
For that,
clearance?
so I will have to take instruction whether environment clearance is there or not, or whether it is required or not. Since
Who has allocated this work to you?
Madam,
What was
it's
the
a-
cause of action to come to this court?
Madam, there was a land encroachment proceeding, madam. My appeal was dismissed on the ground of limitation. Despite there being a delay conservation application, and it was dismissed also on the merit, madam. So we challenged the orders under appeal, madam, filed while dismissing our appeal.
Forget about the limitation. What was there in appeal? You forget
Yes.
about the limitation. Limitation will take care of. What was there what is there on merit?
Can we see the annexure 17, madam? It is at page 150.
100?
50.
115?
115. It's a one paragraph, madam.
ये पढ़िए जरा.
प्रविष्टि के बिंदु पर अपीलार्थी के विद्वान अधिवक्ता का बहस सुना दिनांक 15 फरवरी 17 को अंडर सेक्शन 11 ऑफ द एनक्रोचमेंट एक्ट के तहत दायर अपील आवेदन एवं कालापत्र को शांत करने हेतु अंडर सेक्शन 5 ऑफ लिमिटेशन एक्ट तहत प्राप्त आवेदन दिनांक 16 को दायर आवेदन तथा निम्न न्यायालय द्वारा बीपीएल केस नंबर को पारित आदेश का अवलोकन किया. अवलोकन से स्पष्ट है कि अपीलार्थी का अपील आवेदन का बाधित है.
How much was the delay?
Well, the petitioner came to know about the impugned order on 18th of January, and it was supplied to him on 24th of January 17. And order is dated 24th of 11 2016. Order impugned in the appeal.
नहीं, इसको मेरिट पे डिसाइड करिए. बीपीएल प्रोसीडिंग है, कोई ऐसा भी नहीं है कि 10-20 साल बाद आए. You decided on merit, we'll dispose it of.
We may be given an opportunity to file a response to
कुछ नहीं देखना है. अपील आपका मेरिट पे डिसाइड करा देंगे. इससे क्या लेना देना? Your cause of action is the appeal, no? That's it. You just tell me.
May I just give one submission, Your Lordship? What Your Lordship is suggesting, very much true, delay can be continued, Your Lordship. It can be decided on merits.
Yes.
But as on date, Your Lordship, the encroachment which was at that relevant time
was the
Dumping of waste
the
material.
dumping of the waste material was up to the height of 70 feet. 70 feet. Now they have also taken a step, in a way accepting that they are encroacher, to convert it into the green land encroacher. Now it is as per our report, the current report. Now it has come down to 20 feet. So they are taking a step for developing into the green belt. We have no objection that their appeal should be decided, but as of now, this is the situation, Your Lordship, that some work is being done by them also for removal of that waste material. This is only for the
So
knowledge
some
of
work
the
is being done by them.
Yes, Your Lordship. Continuously done.
Continuously
Yes.
done for the purposes of
Removal.
rectifying their error.
Yes, yes,
Right?
yes, Your Lordship. Yes.
So if the error is rectified, the appeal will become infructuous.
Yes,
What's
yes,
the big
Your
deal
Lordship.
about it?
That is the law. Your Lordship. No problem.
Right?
Yes.
And if you have a fresh report,
Yes.
if they have any objection to that report, that can also be considered by the appellate authority.
Yes, Your Lordship.
Correct?
But, yes, Your Lordship. But just one line may be observed, Your Lordship, that in view of the pendency of appeal, they should not stop this removal of work. Your
तो
Lordship.
तो टाइम फ्रेम करके डिसाइड करना है, ऐसा थोड़ी यहाँ पे
Yes,
डिसाइड
yes, then-
बताइए क्या बोलना?
May I only like, my lord, let this case come on Monday, my lord. Since our stand has been that there is no encroachment, that is,
Very good.
the
There
land
is
does
no
not come
encroachment.
within the definition of public land, my lord.
Not, that will be decided on merits. That your case has not been decided on merits. You see, you have two things. You have 2 points. One is it is not a public land. Second is that you have not violated any law. Right? So far as BPLD proceeding is concerned, they are not supposed to decide whether there is any pollution or there is no pollution. That is not the jurisdiction of BPLD proceedings. BPLD proceeding will be on the point whether it is a public land or not.
Yes.
And whether you are to be evicted or not. And if you have already evicted, then you should not have any grievance. क्या बोलना है बताइए? आइए आप सेकंड आपने समझ के आइए। यही करेंगे, आपका ये ऑर्डर सेटिस्फाइड करके हम डेबिट कर देंगे। 3 महीना में डिसाइड करा देंगे, बस हो गया। ठीक है, शोकॉज फाइल किए थे एनफोर्समेंट में। BPLD proceeding में तो you participated in the proceedings. Your hearing was done. You said that hearing was done, but you could not get the order.
Order in time.
आइए सेकंड आप सोच लीजिए, यही करिए। अननेसेसरी इन सब चीजों के लिए एक पन्ना का ऑर्डर पास कर दिए हैं, आपका एक वैल्यूबल राइट तो लेकिन कानून लचीले हैं।
For hearing item 9, WPF 3759 of 2009.
Yes, petitioner.
It is against an order under section 26(2) of the Jharkhand Shops and Establishments Act.
Where is the private respondent?
It has come for the first time. I was only praying if I could get one accommodation, we could see the records LCR and it can be kept in final disposal next week.
You tell me that which case should I take up?
Otherwise, I am ready only the LCR part. The depositions have been annexed to the writ petition. Only the documents are not part of the writ petition. The short point involved is that it was a case of theft of some property of the petitioner
It is
company.
only on back wages.
It is
You have challenged only on back wages.
the challenge is on both. There is reinstatement with 50% back wages. The challenge to reinstatement is on the ground that theft or at least an attempt to remove or hide away the company's property, which is separately stated as a misconduct in the certified standing orders, has been admitted, but merely, and therefore section 58 of the Evidence Act applies, which says that an admitted fact need not be proved, but still an inquiry was conducted only to fulfill the requirement of the proviso to section 26(1) of the Shops and Establishments Act, which says that if an employee is being punished for misconduct, it has to be done after an inquiry constituted for this purpose. But in his reply to the charge sheet, he admits the charges that he had taken it, the 3 liters of shocker oil and and 5 kgs of rubbing compound and handed it over to one Budhanlal Munda for keeping in his quarter with a view to use it in his personal motorcycle. The reason why it has been set aside is that the learned Labour Court has presumed that it was a reject commodity and was therefore worthless. But even in his own charge sheet, so reply to the charge sheet, he understands that reject does not mean it is worthless. And he
Rejects are not
says,
worthless. Rejects of any industrial unit is not worthless.
yes, therefore that is the.
It could be a waste for one, a raw
Correct.
material for another.
It does not meet the quality standards, it is
There
not
is no,
sold in
there
the
is no
market.
concept of complete waste.
Correct.
100% waste. There is no such concept.
Yes. So that is
In
the
science, at least in
misconstruction
science.
by the Labour Court, that because it was reject and because it was not taken outside the factory, therefore.
Who is for the respondent? On case, no?
Mr. Tiwari appears.
Yes. Who? Vishal Kumar. WPH 3759 of 2009. Also for the parties are present. Counsel for the respondent submitted that this matter has to be argued by Mr. Vishal Kumar Tiwari, who is in another court. Counsel for the petitioner also submitted that he has to go through the records. Are you ready?
So records that has to be seen.
Okay, इनका clearance record is. The counsel for the parties jointly submit that they have to go through the records which have been received and pay for them. कब के लिए आपको चाहिए? बताइए.
First week launch.
Close this case for final disposal on 2nd of December. Parties to file short synopsis of the case and the judgments they seek to rely upon by 29th of November.
Item 10, WPL 2429 of 2010.
With the facet of honor to cases. Given the senior counsel was leading me, we are pretty consistent.
The domestic inquiry was fair and proper.
No, my lord, they held
Unfair.
the learned Labour Court held the domestic inquiry to be not fair and proper. We have
And
challenged
then
that.
evidence was laid.
Witness is also not supported to the case of the management laws.
Then after the domestic inquiry, our domestic inquiry was set aside and the learned Labour Court decided the matter.
On fresh evidence.
Fresh evidence everywhere.
What is the point?
The point is that the allegation against the respondent workman is of having assaulted a fellow employee.
That assault was proved.
As far as it was proved, Your Honor.
Did you file any criminal case also?
No criminal case was filed.
Assault was proved?
Not proved. My lord.
Assault was proved?
As far as it was proved, Your Lordship. Yes. There was bleeding from the nose, there was bleeding from the ears.
They say that the punishment is disproportionate.
My lord, if the assault is proved then within the workplace premises, then obviously that is why your lordship would decide. But I would workplace that in such circumstances, if it is had to be proved, then it cannot be disproportionate under any circumstances.
There is a finding that the management has not been able to prove the.
Then Your Lordship, that is the perversity in the award.
How does it become perverse?
My lord, that the evidence of the workman is there on the basis of even the learned labor court has not, another workman has supported, but the learned labor court has held. He has not seen
Where are the records?
My lord,
The records are here?
my lord, that I have not checked. Sorry, Annie.
नहीं आया. WPL 2429 of 2010, counsel for the parties are present. Counsel for the petitioner submits that the domestic inquiry was held to be unfair, and ultimately evidence was led, and the finding was recorded that the charge was not proved. He submits that such finding is perverse. यही आपका कहना?
Yes, my lord. And also I would submit that the level of evidence required, there are a number of points, Your Lordship, which I need to argue. That they are saying that the second eyewitness had not seen it. There is a fundamental principle in domestic inquiry, even hearsay evidence is permissible, provided there is a proper correlation there.
Let the records be called for from the concerned court. Annexures से नहीं देखते. कुछ भी missing होगा we do not. Right? आधा सुनने के बाद फिर body.
No, it's
This is reference case number 10 of 1998, decided on 25/1/2010 by Learned Labour Court, Jamshedpur. This order be communicated through fax. Post this case for final disposal on 11th of December.
Item 11 WPL 4497 of 2010.
In this case, counsel of the respondent is unavailable, so he has not. So only.
Who is the counsel? Who is the counsel?
This is Jalsa madam. So only he has taken for 1 day also. He posted Monday.
What is the matter?
My lord, this matter deals with termination of the workman on medical grounds. The workman has subsequently been substituted, but the original workman was
Termination on medical grounds.
yes.
What was his date of superannuation?
My lord, his date of superannuation. The date of his termination, I can give that, Your Lordship.
Because the award is that he would be paid till the workman from till the date of superannuation. From entire back wages from 11/5/1999 till the date of superannuation. What is the date of superannuation? How much is the amount involved? 11/5/99 till the date of superannuation.
Lordship, only 1 day accommodation. And
थोड़ा सा preliminary question पूछ लेने दीजिए ना, ऐसे नहीं करिए. Otherwise what happens that if you open the file and then start on the same day, then there could be some gap. So we are just trying to find out how much is the amount involved. हो सकता है आपकी ज़रूरत ही नहीं. ठीक है? He was directed to be paid back wages from 11/5/99 till the date of his superannuation. And the award was passed on 29/3/2010. So he must have superannuated shortly.
You have to not calculate it. If this is a query, not will exactly calculate
It appears it's a very short.
It's not of much significance. If it is only of 5 years, then what we can.
Not even 5 years, 99 and then 2010. It is, we do not know. We have to find out.
99 to 2010 is almost 7 years.
Yes, 7 years. इस बीच वो कब रिटायर हुए, कब क्या हुए, so you have some instructions.
I will have to take instructions.
वो पीछे बैठते हैं आपको instruction देने के लिए.
Lord, we'll have to check it. We'll have to verify it.
If there is a short time, then there is no point.
Yes.
If it's a very short
Yes,
period,
yes,
then there is no point unnecessarily. Why should we decide such a case on merit? It is not a case of.
Correct. I entirely agree. Also, if something is to be payable, Lord, I will be the last person to argue for
Yes.
a single workman on the legal issues and like in Kalsia's by case. I feel that notice should be given, sir. And therefore, accordingly, we have not offered. So, accordingly, I will decide about this also. Let me see.
Learned counsel for the parties are present, counsel for the respondent prays for time and submit that this matter has to be argued by Mr. Mayank Mohammed Sinha. From the perusal of the above, it appears that the concerned workman has been directed to pay back wages from 11/5/99 till the date of superannuation. However, the date of superannuation is, however, counsel for the petitioner is unable to give the date of superannuation of the concerned workman. He seeks settlement. Tuesday? Choose your date, whatever suits you. Post on 26th of November 2024. He may also seek instructions as to whether the petitioner still wants to pursue the matter, considering the quantum of relief involved in the present case. Okay?
Item 12, WBC 863 of 2011, along with item 13.
In this, I checked the file today. In 2013 and 14, 3 counter affidavits were filed. But in our copy, I just have the amended writ petition. We had prepared only on the basis of that maybe there is no counter affidavit, because yesterday even on the website, it was not reflecting that counter affidavits have been filed. I will have to reconstruct the file, Your Ladyship. Any date may be posted and we can argue the matter. Because without perusal of the...
Why is Dena Bank?
Dena Bank was the person to
whom... In pursuance of the order passed by this court, will you not may kindly have the look to that order. That is dated 29/8/2011. Order number 8. Detailed order. This gives the little background of the case. 29/8/2011.
A mortgage deed was registered, Your Ladyship, by ISDC, the prior allottees, in favor of Dena Bank, and therefore Dena Bank is a necessary party in the matter. But since Dena Bank is no longer existing, Bank of Baroda was supposed to be issued notices, and in 894...
I'm not able to get that order. What is the date of the order?
29/8/2011, order number 8.
Might be in the case of serial number 15.
I can pass on my list.
WPC 1249, that order might be in the said file also.
पहले हमको कहानी सुनाइए. What is the story? What is the story? Let us try.
This covers the entire history.
इसका दूसरा केस में
हो सकता है दूसरा केस
1249.
दूसरे केस के रिकॉर्ड में है. वाइड ऑर्डर करके लिखा हुआ है. तो मेन ऑर्डर दूसरे केस में ड्रॉप हुआ है.
This order may be under CWPC, WPC 1492. 1492.
इसमें भी नहीं है. 1492.
1492.
Order number.
Have you also got that?
Yes, yes.
this gives the entire background and history.
29/8/11
29/8/11 order number 8.
इसमें तो छोटा सा ऑर्डर है।
Sir, हो सकता है, I'm sorry madam, this is the order which was
दिखाइए
passed.
सर। हाँ यही तो है, इसमें क्या है, इसमें तो छोटा सा ऑर्डर है, इसमें तो कुछ क्या बैकग्राउंड है। They have parties have agreed, newly added respondent, इसमें तो कुछ बैकग्राउंड नहीं दिया हुआ है। इसको जरा पढ़िए, आप कौन सा पोर्शन पढ़ना चाहते हैं?
जी नहीं, entire background and the history that has been narrated and that's all.
Where is that?
जी
ये order dated order number 8 पढ़िए इसको।
ठीक है। The office report so and so, then 12/29. Council appearing on behalf of the petitioner has filed an intervenor application in the writ of petition 863 of 2011 and 1894. So, since the connected writ is hereby, they are already party, need not be added as a respondent in two petitions. Thereafter, thereafter, this was the order 16 June 2011.
तो आप जो इतना देर से
16
तो गलत ही बोल रहे हैं ना?
हाँ 16th of June 2011.
पढ़िए सर।
Order number 6.
पढ़िए।
Having heard counsel for both sides and looking to the contentious issue raised in these writ petitions about allotment of the industrial plot number 35, large sector, Aditipur Industrial Area, Jamshedpur, which was originally allotted to Indo-Dutch Metal Chemie Limited, hereinafter to ID MCL, was on lease for the period of 30 years. The lesser is Aditipur Industrial Area Development Authority and the original lessee is IDMCL. The lease was executed in the year 1995 on the basis of promises that industry will be started. Never such effective industry was started on the aforesaid industrial plot, and therefore it appears that as per section 62A of the Bihar Industrial Area Development Authority Act 1974, the lease was cancelled on 10th of May 2006. But during this intervening period from 1995 to 2005, it appears that a letter was written by the Aditipur Industrial Area Development Authority that the leasehold land can be put as a security and loan can be obtained from the financial institution. This letter is on record, which is dated 8th of January 1998. Counsels for both the sides have read and reread the clauses of this letter, including the paragraph numbers 3 and 4 thereof. On the basis of the aforesaid letters, original allotee, that is IDMCL, applied for the loan from the Dena Bank, and the cedable amount was obtained toward the loan by the original allotee. This loan was obtained of rupees 5,700 lakhs. The Dena Bank thereafter, in pursuance of the section 51B of the Securitization and Reconstruction of the Financial Assets and Enforcement Security Bank Act 2002, transferred such financial assets to the Asset Reconstruction Company India Limited, which is a petitioner in WPC 894 of 2011. Thus, the Asset Reconstruction Company India Limited is stepping in this.
What is the date of cancellation?
It is 2006 June. The 10th May 2006.
And in the meantime, you granted them.
No, that was granted earlier.
Granted earlier, loan taken.
Loan
disbursed. Loan taken. Then Dena Bank sold it to ARC.
Assets,
Then ARC had a deal with Adhunik.
The dispute is this, that the Dena Bank had advanced such huge amount of the loan on what basis? Where is the document of mortgage? And for that very purpose, the Dena Bank was made party by the order which is still continuing subsequently. Now recently, again in 2024,
the court has ordered the petitioners to give fresh notice to the Dena Bank. Then it was informed that the Dena Bank had merged into
Bank of Baroda.
Bank of Baroda. Then Baroda Bank was issued. Now they have not come out with the mortgage deed. That is the primary document because that
Who is
was
appearing for ARC?
I'm okay.
Where is the deed? Where is the deed? You must be having it.
Well, I was supposed to appear in this case today, but I'm in difficulty because my friend informs me that for BMW I appeared once. So my junior will be assisting the lordships. I cannot appear.
So let him be there. We don't bother about it. I just want to know where is the deed. You are for ARC?
Yes, ma'am.
Yes, where is the deed?
Minus there is a supplementary affidavit that we have filed,
Yes.
saying that it is already a part of record.
It is already a part
Yes,
of record.
Yes.
Where is the original?
Minus the original is annexed.
Where is the original? Is it equitable mortgage?
Minus your may kindly have supplementary affidavit.
Dena Bank must have handed it over to you.
Yes, Minus.
Where is it?
Minus that was documented by title deeds. Minus submission of title deeds. Minus.
You don't get it.
It is Minus. I'll provide you the copy. Minus may kindly have supplementary affidavit.
Supplementary. I want to know where is the original. Is it mentioned that it is with you?
No, my lords.
Then?
My lords, that is already a part of record in one of the writ petition, my lords.
The original cannot be a part of record in one of the petition. Where is the original deed?
Original
If
deed.
there is a photocopy, there has to be an original. Where is the original deed?
My lord,
My lords, I'll have to.
Yes, your lordship, I'm appearing to BC. I am also the advocate for Arcel. So the original document that the lordship is referring to, these documents have all been filed before TRT Mumbai in the recovery proceedings.
Yes.
And OA was filed by Dena Bank.
Fair enough. So you get a certified copy of that deed because if the original is lying over there, they will issue you a certified copy.
Sure.
Isn't it?
My submission is
But they will issue you the certified copy only if the original is lying with them. You can get the list of documents filed. There is a procedure of filing documents.
Absolutely.
You can get it from them, and then say that the original is lying over there. The moment the original deed is found over there, it means that there was a mortgage. Simple.
Yes. Your lordship, there cannot be a challenge to the mortgage as the learned senior is raising.
No, you see.
Because they have given a permission to mortgage.
No, they have given a permission to mortgage, but at the same time they say that no mortgage was done.
That is what I am saying. It is a belated argument being taken up now after.
Now, I just want to know from you, how did you deal with Adhunik? Was it through auction?
I will explain to you.
Was it through auction or it was private deal?
No, your lordship. An auction notice was carried out in the newspapers.
Okay.
Information was given to Aida Jamshedpur by way of a meeting and by way of a letter, which also formed.
Okay. We have lost connectivity.
And there were 4 parties, and since the property is a leasehold property.
To whom you have sold it to Adhunik? Just a moment. You have sold it to Adhunik. Adhunik is the petitioner over here.
Yes, Your
What is the relief they are claiming?
We are claiming we have come to this court against the original order of cancellation of allotment.
It was cancelled post mortgage.
No, Your Lordship. Yes, post mortgage it was cancelled. And
My lord,
it can't be.
May I tell you the chronological order to explain the case in brief?
You see, today I think all the parties are in a mood to seek time. If we start the hearing, I just wanted to know the contours of the matter.
I'm sorry, Your Honor.
I just wanted to know the contours of the matter because if you are ready, there is no problem. We can hear it for the whole day.
I was being led by Mr. Ajit Kumar, senior advocate. I can't see him on the screen.
No, he has his personal difficulty. He will not be able to assist this court on this matter. You have to make alternative arrangement, or his junior is there to argue the case. Maybe that he is holding wakalatnama for you. Are you holding wakalatnama?
Yes.
So he will argue the matter, or somebody else will argue the matter now? We do not know. He will argue the matter perhaps. No.
Just that I was.
You see, for one matter, we will not hear two counsels. We will hear only one counsel.
So now the learned senior has come, there is no issue.
No, see, he will not. He says that he will not argue.
In fact, once I had appeared in BMW matter, therefore, it will not be proper for me to appear for RCL in this case. So BMW I appeared once. I have been just now informed. I have just now been informed by Counsel Mr. Samir Saurabh. So I was not remembering whether I appeared in this matter for any party. So it will not be proper on my part to appear for RCL.
My lord, then this we were not aware.
We'll give you time. Therefore, there is a difficulty. We will certainly give you time, but we are just trying to find out if the original document. Firstly, if the original is there, you should file. You should get a certified copy, right? And also get the list of documents by which it was filed before the DRT. That you can get it very easily. There should not be any problem on that. Then, if the original is there with you, then under such circumstances, if the mortgage was prior to cancellation, they have no business to cancel it. Simple. They cannot cancel it like that if it was prior to cancellation. The mortgage was prior to cancellation. There must be any original proceedings there. OA was filed.
Yes.
Mortgage was declared valid.
Yes, Your Lordship.
Where is that order of DRT? मुंबई वो भी नहीं लेके आए तो क्या लेके आए हैं?
Your Lordship, may I kindly submit, since the learned senior is not in a difficulty to argue this matter, and I had briefed him yesterday evening, so may kindly allow us some time.
I will allow you time, but these are the things which would be required. If the mortgage has been declared to be valid by DRT, then that order is required to be seen.
And then we will argue.
And then after that declaration, the property has been sold under SARFAESI. If the IDA had any grievance against sale of property, they should have challenged it before DRT, which they have not done.
Yes.
So their relief is absolutely barred by law.
Your Lordship, if I may take a minute, what has happened is IDA is under the strong assumption and apprehension that since they have cancelled the lease in 2006, since the lease has been cancelled, they are saying that there was no mortgage, and even if mortgage was there, the lessee has no right.
Just a moment. If a property is sold under SARFAESI, whatever be the right of any third party also, they have a remedy under the Act, and they cannot.
So we filed an appeal. The appeal was dismissed on various grounds, and which is why we have come before Your Lordship in the writ jurisdiction.
You filed appeal where?
The appeal was filed before the Secretary Industries, challenging the order
So see,
of IDA.
you just, both of you, all of you rather, or why these three matters are on board? Why these three matters?
Two matters are on
For one plot, there are all the claimants are for one plot. Plot is one.
Okay.
Property is one.
BMW.
Who is in actual physical possession of the property?
I present my lord one Adhunik is
First case.
Since the order of
Adhunik.
Yes.
Okay.
Since the
Because
order,
that was handed over, the possession must have been handed over to them by ARC.
yes,
So they are in physical possession of the property.
a status quo order is there.
So they are enjoying it. Simple. Status quo order is there, they are enjoying it.
They are enjoying it. And we are in serial number 15. We were allotted after cancellation of this, we were allotted our project was approved.
You see, it's a very simple matter. There is no complication in this. What is required is a sequence of events.
That we can get.
And if you have not challenged the SARFAESI action, you cannot challenge it like this.
But what has
that
happened?
We will not permit.
No, the SARFAESI actions were started subsequently after communication of the order of cancellation.
Communication means that has got no meaning. If there is a mortgage, If the property is auction sold,
was
and
not
if you are
auction
agreed
sold.
by the sale of that property, you have to challenge it.
But the bank will have to come forward showing that whether it was auction sold or not, documents has to be brought.
No, the property was sold to ARC. The ARC has right to put the property for auction sale.
It was not auction sold. That was a private
No,
arrangement.
whatever,
Yes.
we do not know. They say that surface action was taken and then it
If
was
you let
sold.
them bring it on record, they cannot justify their action. Everything behind the back, your lordship.
That was not the
Bank will
surface.
have to come clean, your lordship.
You get it? Do you get that, Mr. Counsel? I don't know your name. Who is it?
Mr. Rajiv Singh.
Mr. Rajiv Singh, do you get what did they say? They say that the property was not auction sold. Okay, so you have to at least bring the paper publication on board, whatever it is. These things are required. क्या खिचड़ी बना के रख दी है? खिचड़ी बना दी है ना?
खिचड़ी बन गया लड़का। हम लोग तो अलॉटेड
Will your lordship permit me to say, I hope this type of paper book has been given to the court. Yes. And your lordship may kindly see the page number 177. That this contains only all the order set and sequence wise. 177 is the order of the appellate court, and the sequence of event is given at page 182.
Does the appellate court say that there was no mortgage? ये नया कहानी edit में शुरू कर दी. If the appellate court's order is under challenge, we'll only see the order. We will not permit you to raise a new
raised for the first time.
We will not permit that.
Raised on mortgage.
नहीं चलेगा ना ऐसे.
Appellate order is 177, relevant part is at 182.
One
182.
Yes. Following facts.
Following facts are read.
Yes. Can you let us see the facts?
Para 3 may be seen of the para 3 of the impugned order, which is on page 6, which are facts which are admitted. The permission to take financial assistance from Dena Bank was exceeded by the IDA on 8/1/1998. So they were properly informed about this.
That was conditional.
The 8/1/1998 letter has also been annexed. We have annexed it in the first writ petition. That is there as annexure 1.
That is also part of this. That is also part of this. Again.
Once you give consent for
yes, that was
mortgage,
condition.
once you give consent for mortgage, They don't need to seek any permission from you for
But
allotment.
that your lordship may kindly the permission. That is annexure A to this book, page 1A.
This one?
This.
Page
That-
1
That is page 1 is the original and typed copy is on the next page.
Page 1.
Relevant part is condition number 3 and 4. Then 4 is relevant, that has to be Adityapur Industrial Area Development Authority further agrees that so long as their money remains due to the financial institutions, the authority shall not enter into the possession of defined premises or shall neither take possession or sell the same, nor shall the lease be determined without giving. Here we say that June and the action started by Dena Bank in the month of December, without giving prior notice to this unit and the financial institution, unless the financial institution fails or neglected recent remedy the breach of the covenant of this lease within 90 days of the said notice for such longer period as may be allowed by the authority. So, in spite of the receiving,
इसको हिंदी में समझाइए, हमको नहीं समझ आया. अब जो अंग्रेजी इसमें लिखे हैं ना, एक सेंटेंस आधा पैराग्राफ, पूरा पैराग्राफ is one sentence. I'm not able to understand.
No, we have to understand, like, I am sorry, that what I feel, that they intend to say that if the IDA will not enter into the permissive nor cancel the lease without giving prior information to the lessee and to the bank, the financial institution, and only after 90 days they can act. So after giving such notice and information, in this matter, the lease was cancelled on 10/5/2006, and the Dena Bank started acting for realization of dues in the month of December 2006.
Did you issue notice to Dena Bank?
Yes,
that you want to cancel it?
That is page number 9. That is page number 9. We intimated to the Dena Bank.
Lordship, I am sorry.
Yes.
I am able to speak into the mic of proceedings. I may be allowed to come physically in the court. I am unable to hear.
You see, we need absolutely uninterrupted deliberation. So if there is a technical problem, then it will create.
Your voice is coming out.
I know your voice is also breaking, so my voice might also be breaking at your end. अब ठीक है, अब बताइए कब करना है? लिस्ट ऑफ, इसके अलावा कुछ लिस्ट ऑफ डेट्स बनाए हैं कुछ? You have prepared the list of dates. Every sequence should be mentioned therein.
But I'll verify and submit it on the next day.
Yes, we want the list of dates. This case cannot be decided without the list of dates.
I make a thorough.
How the parties are
Share
proceeding.
the affidavit with all the petitioners. Unless we.
Who are you?
We are in the third case also. I am the petitioner. I have been allotted the plot after cancellation of the lease.
You have not got the copies of the petitions?
No. This is affidavit of bank. If bank has filed any affidavit, they
Unless
should
we
share
have
it
filed
with
it in the case of 894.
They should share it when all the cases are tagged, Your Lordship.
When all the cases are tagged,
I'll share the supplementary affidavit.
It has not given to the IATA also, as per my instruction.
पेपर बुक कौन बनाएगा? आप बनाइए. तीनों केस का, 3 केस में कौन पिटिशनर है? आप ही हैं.
नहीं,
First we sign the petition.
Whosoever is the petitioner shall prepare the paper book and share amongst all the councils, irrespective of the fact that whosoever is party, not party, you share amongst them, amongst yourself. Now at least the mortgage is not in dispute. That is not in dispute. Please don't try to dispute something which is not in dispute. That is not in dispute.
No, mortgage is not in dispute.
Your entire case is that this clause has not been followed. We'll see whether it has been followed or not followed.
Well, the intimation, if Lordship, I have pointed out, page 9, and the reply of the bank is on page 11 of this very bunch.
We will see that.
So
We'll see that.
Bank was well aware about the cancellation and all. What has happened with 57 lakhs, 5700 lakhs, and the industry which took the loan, they run away with that, without doing anything on the ground. That's the difficulty. 5700 lakhs, that was the reason.
Bank also disbursed it without ensuring the utility of the amount.
We will not comment on what they have done.
No, certainly, but the fact
Therefore,
is
bank's affidavit, Lordship, if we will be able to assist your Lordship with a better manner.
Who is for the bank? Bank of Baroda? You are appearing?
Bank, my lord. The property was already transferred to ourselves.
So
Yes.
we have stepped into the shoes of the Bank of Baroda.
Basically, you have to
Yes.
deliberate.
Yes.
The agreement that we enter that time, all the documents.
No, that
Deed of
it's
assignment is
well
already
known.
there.
All the documents are handed over. At times, the documents are not found here and there, and then they keep on searching the documents.
Yes, my lord, it has to come
There is
from-
no dispute on mortgage. There is no dispute on mortgage. Please don't dispute anything which is not there on record. The sequence of events, these clauses, is required to be seen. What is the consequence of these clauses? That is also is required to be seen. And what will happen when the property is already sold?
Whether the sale is valid or not.
Who will decide whether the sale is valid or not?
Lordship, the issue is, here, Lordship has a concern. The issue is, once your Lordship a leasehold rights were mortgaged. So there is a provision that IDA can cancel the lease, but giving because.
Where is the
mortgagee
sale
also-
certificate? Sale certificate must have been issued in your
There was
favor.
no auction, it was a backhand deal.
No,
Therefore, I say
where
bank
is the sale
affidavit
certificate? Where is the transfer document?
There is a transfer document is there.
Where is the sale certificate?
Sales certificate is not on record.
Without sale certificate, how a transfer document can be done? Do you get that? There has to be a sale certificate if you have sold it through auction or whatever. Mr. Singh, if there is a sale through surfacing, or if it is a
it was not
It was not sold through
just
surface.
please
Not
hold on.
surfacing.
Just if there is a sale through surfacing or sale through auction, then under such circumstances there has to be a sale certificate.
What documents are required?
Sale certificate.
I'm taking a note of.
There is a registered deed of transfer? No.
Deed of transfer is there.
Deed of transfer, is it registered or unregistered?
Registered deed of transfer. I'll wait.
These things are required to be seen. It might not have been registered because IDA might not be a party to that, isn't it?
No, not
Registry नहीं हुआ.
Not at all.
Is your lordship referring to sale certificate?
Yes. There must be a sale certificate if it is sold through surfacing.
It is.
Agreement or sale, but not the sale
Your lordship,
certificate,
this
but
is
we bring it
not
on
mentioned. There could not the property is owned by IDA and it can only be changed in the record.
You just
Most
comment.
IDA with relevant documents and the certificate issued by ourselves, it is when they raise this issue.
No, I just want to know if a property is sold through auction, then under such circumstances there has to be a sale certificate, isn't it? There has to be a sale certificate.
It's not being pledged. So I will again take instructions from ourselves. Because the 25% amount was paid.
Yes.
And the remaining was bank guarantee.
This will get
Bank guarantee.
By way
there
of
was
bank
a
guarantee.
clause that
Very good.
the IDA issues the
Payment through bank guarantee. Very good.
Your lordship, because IDA
Anyways, your voice is breaking.
no buyer will
If there is any, you see, we have deliberated for around 15-20 minutes. You can figure out what are the nature of
Well, let's
queries.
we'll get the instructions on that.
Your Lordship, may kindly fix another date and allow
You
us
choose your date.
For a moment, page 79, if your Lordship may kindly read.
Your Lordship, this I am
79.
the hearing question that I be allowed to be in the court. I was under the impression, okay,
I will, from the top,
since he's not,
only
then it
2
is
lakh,
better that I should be there in the court.
215 lakhs were paid and 645 next clause was still due.
Your Ladyship, we have received a no due certificate from RCL which are annexed at page 8, which shows that 3 checks have been disbursed for the amount and we have paid that total amount of 872. The check numbers we have, they have said, RCL themselves, the legal advisors of RCL, they themselves have issued the no due certificate. I have annexed it also.
By Ida?
To Ida, they have written a letter. RCL's representative has written a letter to Ida saying that they are issuing no due certificate towards us because we have made the payments. And 3 checks, by 3 checks we have made those payments. And the date has also been given. It is a letter dated 24th May 2010.
Madam, the point is, what is the manner in which the property has been transferred? Is it through auction sale or it is through private arrangement? What have you done?
Your Lordship,
Because at the end of the day, they permit you to realize the dues. They permit the bank to realize the dues as per the terms and conditions. Now you enter into private treaty, and then a deed is signed or whatever. Then how this kind of transaction can be accepted?
I will take instructions from each and bring the relevant documents also.
आपके पास तो स्टे है, आपको क्या है, इंस्ट्रक्शन लेते रहेंगे हर दिन? अब नहीं चलेगा ये इंस्ट्रक्शन का काम.
Only one indulgence will be granted. We will bring everything on record.
Ida is absolutely clueless. They do not know what exactly happened.
We have written letters. They have written letters. They have
What has
received
come?
the letters.
What has come in the appellate order may not be just acquainted with those facts, and what has taken place behind our back, we are not very much aware about those things.
Your Lordship, initial cancellation, the authority did not
But
have
the-
power
every
to
action has
cancel
taken
the
place
allotment.
after the
Managing
cancellation.
director has cancelled it.
After the
Where
cancellation of the
authority is
lease.
the person who is supposed to cancel it. As per the Bihar Vyada Act, Your Lordship, that itself is in question.
That is under challenge in one of the petitions.
Your Lordship, in the appeal order, we had taken that ground. It was not considered. At the outset, only the appeal was dismissed, saying that we do not have any locus. None of those factors have been ever considered in the appellate order.
These are all batch.
Yes.
2 दिन लगेगा. We need 2 days. So make yourself available for 2 consecutive days. पूछिए कब आएंगे? The learned counsel for the parties are present. Counsel for the respondents have submitted that that some of the affidavits filed in one or the other case have not been served upon them. Counsel for the petitioners are directed to prepare a paper book with continuous page numbering and serve copies on the other counsels involved in the present case. other parties involved in the present case. The learned counsel for the parties are also directed to prepare a list of dates with reference to the documents / pleadings in the present case, in the present cases. And also give the list of judgments, provision of law which they seek to rely upon. However, during the course of hearing, it is not clear as to how the property has come in the hand of the petitioner, more than the manner in which the property has come in the name of the petitioner. From the same petitioner?
Only in 12 the petitioner is Adani, 13 it is RCEL, 14 it is BMW, 15 is Anjanya Constructions.
But the entire property is in physical possession of
Adani.
How the property has come in the hand of Adhunik Power Limited, the answer to which would surely lie with the Asset Reconstruction Company, right? The Asset Reconstruction Company who has filed the petition being WP, उनके RCEL का कौन सा है?
894 of 2011.
894 of 2011 is directed to file a supplementary affidavit in WPC 894 of 2011 with copy to all the councils appearing in other records. हो जाएगा उससे? एक affidavit से हो जाएगा? Or you want to file in all the records?
One affidavit and copy
As it has made to understand to this court that one affidavit in WPC 894 of 2011 may serve the purpose for all the petitions. Therefore, at this stage, this court is not directing filing of separate affidavits in all the cases. The needful will be done by
There is one more thing subject to they say that some procedure is pending for DRT. They what about the stage of that process also? This is first time we came to learn that this is pending in DRT.
Just the affidavit be filed by 4th of December.
I'll have to procure all the records from Mumbai. It won't take time.
Your Mumbai is there.
You
are placed at Mumbai.
We are based out of Mumbai. Therefore, a little.
You are based out of Mumbai.
RCEL is there in Mumbai. All the records are there.
So
they would be needing some time to procure. I faced difficulty, therefore I was there.
4th December काफी नहीं है आपके लिए?
I'll try my best to procure everything and file it on just in case. Therefore I was seeking.
In case you have difficulty, you pray for time. Right? But you try and do it by 4th. After all, there are private parties who are dispossessed of the property. They are not in possession.
They are in the adjacent land. They are not this. But however, since
they have forcefully entered into the land, cleared all the
We'll see that.
They have made representation for allotment. They have not been allotted land.
There is only a proposal for allotment. There is no allotment per se.
By 4th of December, you do the needful. Rejoinder, if any, by 16th? Yes? Reply to such affidavit, if any, by 16th. हो सकता है कोई co-petitioner respond करना चाहे. We do not post on 18th for final disposal.
Regarding the mortgage deeds, that was not in dispute.
Your Lordship,
That is not in dispute.
That may
Mortgage
be
is not in dispute. Things which are not in dispute.
because in the last order, my Lord said was recorded. It was the submissions of the respondents that mortgage deed
No,
was.
I have not said. I have
No,
not said.
Not, my Lord, not, but by the coordinated bench, my Lord. There was a specific direction to.
Even
Therefore,
if
if
you
Your
bring it
Lordship may
on
record.
record, what's the big deal about it?
Only on the point, my Lord, that it is not in dispute any further.
No, since
ऐसा
the
हम
order
पूरा
of
record
court,
नहीं देखे हैं.
that will amount to revising the order.
We will not do it like that. Rather, you as RCIL should be fair enough to bring everything to the forefront. Right?
I'll make
You are a public authority.
I'll make all the endeavors to do that.
He says that the original documents are lined with DRT.
My Lord.
So something must be going on in DRT. What is it that is going on in DRT? Maybe that recovery suit against that company is pending. Possible? And if it is in the recovery proceedings, then OA order must have been passed, holding that the mortgage is valid. You do not know what is happening.
इसमें इन लोग को पेपर बुक बनाना तो थोड़ा पहले हम लोग को दे देने से
पेपर बुक बना के देने आपको लग रहा है नेक्स्ट डेट में होगा? नहीं होगा ना, आपको पता है नहीं होगा. लेकिन अब ज़्यादा दिन नहीं चले. ठीक है, फाइनल डिस्पोजल में ही रखेंगे. मेरे पास रहेगा तो हो ही जाएगा.
हम लोग चाहते हैं कि हो जाए.
4th तक इनको टाइम दिया, अब 18 को रखें ना. उस दिन certainly 18 December we will hear the matter at length and then we'll post it post vacation, right, for final.
Yeah, finding everything in order.
हाँ, एक बार रिवाइज तो करना पड़ेगा ना दोबारा. इसीलिए 18th को एक बार we will see what is the status and then we'll fix it. इसको final disposal में डालेंगे. इतना दिन तक ऐसे चल नहीं सकता. We are posting it on 18th. Yes, you are. We are posting it for 18th. We are asking you to file certain affidavit. And then,
I am requesting if the date can be persisted either Monday or Friday so that I can travel to Ranchi, your Lordship.
no, you see, on 18th, you cannot have your dates like this. Friday may not be possible because it is the last working day. And on 18th also, we are not going to conclude the proceedings by any means. It will not be concluded. We do not know whether the affidavits will be filed or not. But at least we would like to hear the contours of the entire case. The sequence of events, etc., should be made very, very clear. And what is important is how the property has been transferred to Adhunik is something which we need to know.
Whatever is convenient, your Lordship.
18th would be the day.
Alright.
Password case item 7, WPC 5826 of 2017.
The office of the ASGI, perhaps he is in complex in court number 1. He is not. I have informed he is appearing for CBI now, Mr. Anil Kumar. I informed, but just got a message in my mobile that some matter is going on court 1. I pray that Monday he will take him.
You want to file in the reply or?
He also filed.
I have to file reply because we are here recently filed.
Counsel for the petitioner and state are present. Counsel for the state waits for time to respond to IN number 2798 of 2020. Which is 2798 of 22.
Yes.
Let the reply be filed by 5th December, post on 12th. Yes, madam. You are here to tell us what is the situation so far as CBI is concerned.
Earlier also in this case the name will appear in the Piuspati sir and the state is in the there is no mention is there in the CBI matter. Earlier in the 11.
Now you know.
Thus we are not.
Now you have a date also.
Yes.
You can parents record. ठीक है अब मत बोलिएगा अगली बार कि
I just
name of appearance find it.
Item 16, WPL 2947 of 2011 along with item 17.
What is the impugned order?
My lord.
You wanted to file additional written statement.
My lord, this case has a long and checkered history. The first case, there are two cases tried before, right? So in the first case, your lordship, the matter had travelled up to the Honourable Apex Court and had been remanded back. So there we had prayed for permission to be allowed to file an additional statement. That was denied. That was our first time.
So during the pendency, the main case has been decided.
My lord.
So the first case has become infractus.
My lord.
That has become infractus. You did not have a stay, did you?
No, we didn't have a stay. We are not arguing that.
That case has become infractus. Now what do you want?
My lord, in this case, if your lordship will recall, we had given notes of our compilation of judgments had been handed over. Yes, your lordship, and it was given to the other side also. I was praying for some time to argue this case, your lordship, some date for final disposal.
Should I dispose of the other one saying infractus?
My lord, I'll take instructions on this point. Your lordship will keep both because I'll have to give a concession, your lordship, because.
Who are you?
I am for respondent number 3 and 4, my lord.
There are 4 respondents.
My point is that the matter went for execution, my lord, by the labor court, and the matter has been, the execution has been finalized, my lord. That is on annexer.
It has been executed.
जी, खत्म हो गया
Award
केस.
has been executed.
My lord, for one work, this fact is coming up each time. Each court I have to explain this fact.
That has to be ascertained from labor court whether the whole matter has been disposed of or not.
I'm making a statement.
What is the execution case number?
Execution number, that is annexer. The
Election case number बताइए.
This
Execution case number.
execution case number, my lord, is 5/5/2017, my lord. 5/5/2017, my lord.
Who filed this execution case?
Execution case number.
Who filed it?
Labor court sent this matter to for execution, my lord.
Suo moto.
अवार्ड नहीं, अवार्ड जो था ना, अवार्ड जो पास किया गया वो
देख लिया जाए एफिडेविट में
नहीं, इनका एफिडेविट, इन्हीं का एफिडेविट जो है उसी का देखा जाए एनेक्सर
एवरीथिंग इज बिफोर योर लॉर्डशिप।
उसी का एनेक्सर में इस बात का जिक्र किया हुआ है और जजमेंट भी दिया गया है एग्जीक्यूशन कोर्ट का
22/7/2024
एग्जीक्यूशन कोर्ट का जजमेंट इज ऑन रिकॉर्ड। टाटा स्टील का ही एफिडेविट है जिसमें उस रिकॉर्ड लाया गया है उसको
19/7/24।
ये
कोर्ट नंबर 12/7 फाइल्ड ऑन
ये 12 जुलाई 2024 को फाइल किया गया है टाटा स्टील के द्वारा।
ठीक है।
उसी में इस एनेक्सर लगाया गया है इसको एग्जीक्यूशन केस के ऑर्डर को।
बताइए।
जी, उसका लास्ट पोर्शन लॉर्ड, my prayer is that it may be of last paragraph, page 3 of the execution judgment. Page 3.
Yes.
Hence, considering the aforesaid facts and circumstances, the execution case is hereby disposed of on full satisfaction of decree holder. That has been recorded by the execution court, my lord.
You are the only degree holder.
I am four persons where judgment includes 4 persons. One person raised this matter in the court, execution court, and he got some amount. And on the basis of that, उन्होंने कहा दिया कि ठीक है हमको हो गया. तो हो गया तो अगर इस चीज को फाइनलाइज हो गया जब, then it is इस पर अब क्या आर्गुमेंट हो सकता है?
एक ही आदमी का फाइनल हुआ ना, बाकी तीनों का?
बाकी 3 आदमी तो अपीयर नहीं हुए होंगे वहां पर में एग्जीक्यूशन केस के दौरान. नहीं ऐसा ट्रेन कर लिया जाए लेबर कोर्ट से जो किस वेदर इट इज ए टोटल डिग्री हो गया कि नहीं हो गया, ये इसको असर्टेन लेबर कोर्ट ही नहीं कह सकता है इस बात को.
Your Lordship may see your Lordship's order dated 8th of July 2024, which I have quoted in my affidavit. 8/7/2024. Your Lordship can see paragraph 5 of my affidavit.
Yeah.
Paragraph 5 at page 3.
लेबर
that
कोर्ट से
order is
हुजूर
quoted.
एक ले लिया जाए मंतव्य जो क्या फुल एंड फाइनल हो गया इसका.
तो बात बताइए
जी
भाई, अगर आपको मिल गया है तो रिवर्स तो नहीं होने वाला है.
कोई प्रॉब्लम नहीं है.
अगर इस बात को मेंशन कर दिया जाए उसके बाद जो ऑर्डर पास करना हो किया जाए. आई फियर दैट हो सकता है कि अगर ये खत्म हो जाएगा तो हमको हो सकता है कि
Everything I have explained, we were appearing before the learned. But the respondent number 4, yes, the award has been executed as far as he is concerned. But your Lordship had directed the labor court.
Up to date status आया है क्या इसका?
My Lordship.
That is disposed of, right?
Yes.
Because you have also annexed a copy of the order.
Yes, your Lordship. One workman pursued the matter before the learned labor court. The learned labor court sent it to for that particular workman's case.
Who is representing the other workman?
Mr. Sani was appearing.
I am appearing for the Respondent 1.
Are you interested or not interested?
Yes, they are interested because
your order has been executed, not executed.
I don't have any instruction because it relates to Respondent 1.
I am making a statement that only the respondent number 4.
4 only.
Respondent number 4 को छोड़ दीजिए. Delete कर दें उनको?
My lord, his order has been executed. Yes, sir. There is submission.
आपको डिलीट कर देते हैं, आपका कोई काम नहीं.
3 के लिए भी है.
लेकिन 3 के लिए भी हम हैं.
कोई बात नहीं. 4 को तो डिलीट कर देना कम से कम.
तो 4
के साथ सेटल हुआ.
4 के साथ सेटल हो गया उनको.
जी 4 को कर दिया जाए स्कूल से.
The learned counsel for the parties are present. The counsel for the petitioner in WPL number 794 of 2012 has submitted that the award has been executed only with respect to respondent number 4. At this, the counsel for the respondent number 4 submits that under such circumstances, the name of respondent number 4 be deleted from the cost title.
M.K. Jha. Mishri
M.K. Jha be deleted from the cost title as the award has been executed
in his favor.
In his favor. Has been executed ही काफी है. इसका फेवर में क्या हुआ क्या ही बोलना. He has also submitted that as per the order dated 10/11/2022, Mishri Kant Jha has received the amount as full and final satisfaction of the award/degree dated 25/10/20. Counsel for the petitioner also does not dispute this position.
My lord, I will also pray that it be recorded that he is fully satisfied.
Yes.
He will have no more claims.
Yes. Counsel for the petitioner also does not have any objection to this. He submits that it may be recorded that the respondent number 4 does not have any surviving grievance
Claims.
or claim against the petitioner arising out of the imprisonment. Considering the aforesaid submissions, the name of respondent number 4 is directed to be deleted from the cause title, and it is made clear that the respondent number 4 has no surviving grievance against the petitioner with respect to the award involved in the case. Grievance/claim. हो गया. अब बाकी 3 का क्या करना है?
Hello, the date may be fixed, we can argue on it.
ये वाला केस तो इन्फेक्शियस हो गया ना, बताइए रिटन स्टेटमेंट का क्या ही करेंगे?
ठीक है, my lord can
WPL number 2947 of 2011. Counsel for the petitioner has submitted that this petition was filed for the following relief. He has submitted that no stay was granted by this court with regard to the amendment prayed for, which was rejected by the order dated 1/3/2011 by the learned presiding officer, Labour Court, Jamshedpur. And in the meantime, the court proceeded and final award has been passed, which is under challenge in WPL number 794 of 2012.
Well, let both the let them both be kept pending. They can be decided on the next date. Mr. Hanyan will be leading. He may have some points there because we may have the advantage of list pendants also because we had challenged this particular order in time.
Then you argue this additional written statement.
My lord.
We'll dismiss it on merit.
My lord, I was just bringing that a date may be fixed, your lordship. Our other cases I managed to brief. In this case, so not available till yesterday. This morning, I managed to brief on 2 cases. Next date of both the cases can be decided together. Your lordship has recorded.
Counsel for the petitioner prays for time. बताइए कब करेंगे?
Your lordship can fix it on 26. The one case is already fixed on 26.
Post on 26 for final disposal.
Lordship.
को delete कर दीजिए.
जी. Well.
He will be deleted from both the records.
My lord, he can be deleted
for both the records.
No.
I'll modify the order accordingly, but we delete for both the records.
The petitions shall be confined with respect to respondent 1 to 1.
Yes, naturally they are being deleted. His name is being deleted.
Appearance is deleted. Item 18 WPL 7546 of 2011.
Petitioner, you are there in this case? This one? Where is the petitioner?
This was second there are senior advocate Mrs. Emma can request.
Take a second up. Second up. Please, what is this writ petition? They are just seeking a direction.
Well, they are seeking a direction for the payment of difference of wages in class 2.
Yes.
We have filed this.
There is no impugned award as such.
There is an award, Melis. The matter went before.
Refusing?
No, Melis. It was in their favor. Therefore, thereafter they moved before this honorable court in CWJC, Melis. That was also decided.
Okay.
We have filed a counter affidavit, Melis, stating the fact that we have revised their scale to class 5, that is above the class what they were seeking. I was saying that in this matter my senior needs to assist. The
No,
counter
I
we have
just-
stated.
I just don't know. In a case where an award has been passed, the cause of action is only the award.
Yes, Melis.
Award is not under challenge, is it so?
Well, they have not challenged because the award was in their favor. Thereafter, the CWJC.
Execution, we are executing it.
It was not execution. After that, they preferred a writ.
After the award,
Yes, my lords.
that award, that writ was dismissed, allowed, what happened in that?
That is annexure 1 forming part of this, the writ petition which they have filed.
This was challenged by the management.
Well,
We are the management?
Well, I beg pardon. We had challenged the award before the
Yes.
Honorable Division Bench, my lords. Therefore, that was decided in the favor of the petitioner, my lords. But, my lords, that the case is that we have not complied with the direction of the Honorable Court.
So they will go for execution.
Because
Ultimately, if an order is
not
whatever order is passed in the district court, that order merges with the award, then they have a remedy under execution.
That also we have stated in the counter affidavit. Apart from that, we have stated that the benefits of class 5, the difference of wages more than what they had asked for, we have already paid that matter. That has been stated in our counter affidavit. If my lords are keeping it in the second amendment, I think my senior would assist my lords in this matter.
They have a right to get the award executed.
Indeed, my lords.
Yes, madam. सेकेंड हाफ के लिए तो रख दे रहे हैं, लेकिन जरा मैडम से पूछिएगा जो हम बोल रहे हैं, ठीक है? ये तो एग्जीक्यूट होना था ना अवार्ड.
We have regularized that also. We have annexed the document.
You see, they say that they have done it. If you have any surviving grievance, you go and file an execution case. ये रिकॉर्ड किसने आया है इसमें? She will join online or she will come?
Item 19. WPI 4784 of 2012.
Petitioner.
May I submit one thing, my lords? I had filed the Waqf on behalf of the workmen. Unfortunately, I could not face, but I had a talk with one of his friends, and perhaps he's no more, so I just need to verify the same.
At that time, in 1999, thereafter his son was
Son.
He was also there.
I'm not sure about that, whether his son has died or not. So I need to send someone, my lords, to verify. His friend has said that he'll be able to tell the exact within a day or two.
The workman had died on
He had died much
25/1/99.
prior. Now his son, subsequently his son.
He was substituted before the labor court.
Just a moment. Is he a party? His son is a party before this court?
No. It cannot be. It was by the union.
Union.
Union was contested.
But I think I had submitted Waqf on behalf of the son.
He's not a party, I said. He's not a party.
No, it is not.
I'll assist them.
Who are you?
Definitely.
If at the stage of execution, it has to be given to the legal here, that will be taken care of.
Definitely, madam.
Nothing.
Yes. Annexure 1 is the award of the tribunal.
Yes.
Now, the terms of reference is whether the action of the management of Sir Colliery of Sijua area number 5 in stopping Sri Sakaldev Singh attendance clerk from duty is justified. If not, to what relief is the workman entitled? I'll have to go through the award on it. May I place it? The case of the concerned workman is that he was a permanent employee of UDD Colliery area number 5 of BCCL working as attendance clerk. He was transferred to Chanch Victoria area number 12 of BCCL by personal manager by order dated 21/5/76 and he was released by the office order dated 26/5/76. But he was allowed to join his duty at, it should be he was not, due to vagueness of the office order, nor he was allowed to join at UDD Colliery in spite of giving representation to the management. But neither the management of UDD Colliery nor Chanch Victoria Colliery has taken responsibility for joining in duty to the concerned workman. the concerned workman has been restrained to join in duty and in stopping to perform duty without complying with section 25F of the ID Act is unjustified, illegal, arbitrary, etc. It has been prayed that this honorable tribunal be pleased to pass an award in favor of the workman by directing the management to reinstate the concerned workman with back wages since 26/5/76 till the date of his return of duty. Case of the management is that the concerned workman was never stopped from his duties. It has been submitted that an office order dated 21/5/76 was issued from the office of the Director of Personnel transferring 6 workmen from one area to another with the approval of the competent authority. The concerned workman was transferred from Area 5 to Area 912, Chanch Victoria area, and was released by order dated 26/5/76. The peon went to the residence of the concerned workman to deliver the letter on so and so date, but as the concerned workman left the colliery to avoid his transfer, the peon could not personally hand over the letter to him. Therefore, the letters were sent to the registered post, which was returned back with the postal remarks that the concerned workman was not available at his home. He declared sick and meanwhile had left the colliery for the reasons best known to him. The chief personal manager of BCCL issued letter dated 26/6/76 by registered post, calling explanation from the concerned workman, but he did not submit any reply and he did not join at the area and started absenting. In the year 1989, he raised the present dispute on false allegation that he was stopped from his duties by the management of the colliery. In such circumstances, it has been prayed that this honorable tribunal.
After 76, he
89.
89.
14 years. That is one of the points. Yes, in para 4, both the parties have filed their respective rejoinders admitting and denying contents of somewhat of paragraphs, so and so. No evidence has been produced by any of the sides. Main argument advanced on behalf of the concerned workman is that he has been stopped by the management from duty. It has been argued that he was transferred by Unity Colliery, where he was working as attendance clerk as permanent employee of that colliery and worked as attendance clerk continuously. But he had been transferred to so and so by order dated 21/5/76, and he was released by office order number so and so, and he had not been allowed to join at Chanch Victoria colliery, nor he was allowed to join at so and so, though he has given representation to the management. It has also been argued that he was transferred and released from colliery without giving details of his salary, scale and pay, etc. And served workman for the purpose moved application before the general manager, Sijua area on 16/11/87 to resume his duty, but he was not allowed. He also gave another application on 29/5/76, which was received by the management and also general manager on 31/5/76, that he was not allowed to join in the capacity of attendance clerk, but no action was taken. It only shows that the management official was adamant to harass the workman without his. Another letter was issued by the management to the concerned workman for not joining duty. It only shows that one side management does not allow the job.
No evidence was laid.
Nothing. No oral document.
क्या है? What is this?
कुछ नहीं.
It has to go.
Yes. Now the election, therefore.
And victimization also, harassment also.
सब चीज
सब चीजें.
no evidence is there. This is the कुछ कोई evidence नहीं.
अब तो कुछ हो ही नहीं सकता. The workman
He
is
is
dead.
no longer in.
WPL number 4784 of 2012. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the impugned award is expressly perverse inasmuch as the award has been passed without any evidence, without taking any evidence, and finding has also been recorded that the management officials were adamant to harass the workman without any fault. The Learned Council submits that the paragraph 4 of the impugned award reveals that both the parties filed their respective rejoinders admitting and denying the contents of some of the paragraphs of each other's written statement. But no oral evidence has been produced by any of the sides. The Learned Council submits that even the documents were not proved before the Learned Court, much less the allegation of harassment. The Learned Council has also submitted that at this stage the matter cannot be remanded back for fresh consideration as the workman had died on 25/1/1999 and his son was substituted in his place. He submits that there is a direction for payment of 50% back wages. On the respective case of the parties, he has submitted that the order of transfer was issued, but the concerned workman did not join the duty, and the order of transfer was 26 and it was way back in 1976, and the industrial dispute was itself raised in the year 1989. The terms of reference are as under. The Learned Council, appearing on behalf of the respondent, though has opposed the pair, but he also does not dispute that the award has been passed and direction of 50% payment of 50% back wages has been passed without any evidence. Considering the aforesaid facts and circumstances of this case, this court finds that the impugned award has been passed without any evidence, and it has been clearly recorded that none of the parties chose to produce any evidence. Considering the nature of reference, the allegation was made from the side of the workman. Therefore, at the first instance, it was the workman who had to prove the allegation. It is not in dispute that order of transfer was issued, but ultimately he did not join. The fact also remains that the order of transfer was of the year 1976 and the industrial dispute was raised only in the year 1989. Considering the totality of facts and circumstances, the impugned order is expressly perverse and is accordingly set aside. Communicate.
Item 20 WPL 4810 of 2012.
Yes, petitioner.
What should we pray for not meeting?
Why you?
Seeking instruction from the client.
What is this matter about?
Because the findings came quite severe. So
The matter was held to be not maintainable. This is sales promotion. Where is the respondent? Who is your senior?
Rajesh.
Rajesh Kumar. He is well aware about sales promotion committee. Where is he? Not today, matlab? Tomorrow?
yes. No. Yes.
He has a remedy under the ID Act. Call him. बुला के लेके आइए. Second half में बुलाइए. He is aware of this law. Call him.
Item 21 WPL 4963 of 2012.
Petitioner.
Last day when I had spoken to petitioner counsel, he informed that
Who is the petitioner's counsel? Mr. Shekhar Prasad Sinha.
Yes, probably. He said he will inform the court on the next date. The matter was not taken up on the last date.
Call Mr. Shekhar Prasad Sinha. उनको बुलाइए. The court छोड़ के भागने से नहीं होगी. You call her. If she has it expired, then you just record it. Nothing, because now she cannot join her duty by any means, right? बुलाइए second half. हाँ बताइए.
सीरियल 20
हाँ क्या हो गया?
सिर्फ एक नॉट टुडे ही आज मांग रहे हैं बस नेक्स्ट वीक में डन की इन द मीन टाइम एक्चुअली ये फाइल लेट सीनियर्स ऑफिस फाइल तो आ गया है हमारे पास चूंकि केसी है तो एक बार पता चल जाए क्लाइंट का क्या इंस्ट्रक्शन 12 के 2012 का केस
आप तो इंस्ट्रक्शन का तो बात कर रहे हैं. वो बोल दिया है नॉट मेंटेनेबल. उसके बाद आप क्लाइंट को क्या रिलीफ दिलाएं? आप भी बताइए. यू जस्ट टेल अस द केस वाज हेल्ड टू बी नॉट मेंटेनेबल. 2000 कब का ऑर्डर है?
इम्प्यून है एनेक्सर 9
2012 का ऑर्डर से नॉट मेंटेनेबल बोल दिया ना.
यस
ठीक है. उसके बाद ही इज नोवेयर. You just see the agony of your client. Not maintainable है या नहीं है, कहीं जाएगा ना बंदा. क्या कर रहे हैं? आज केस टेकअप हो रहा टाइम है.
No, I am only
फिर बोलेंगे केस टेकअप नहीं होता हाई कोर्ट में.
I am only praying.
Why not today? ये तो इतना छोटा सा चीज है, इसलिए आपको इंस्ट्रक्शन का कोई काम ही नहीं.
एक बार बुला लेते हैं जो भी कहें एविडेंस नेक्स्ट
Who is for the respondent? Counsel for the petitioner is present. Nobody appears on behalf of the respondents. Apurva Singh was appearing on the last date. As per the impugned order, the case was said to be not maintainable under the provisions of Bihar Shops and Establishment Act. Counsel for the petition seeks a judgment. Post on Wednesday under the heading for final disposal. in the supplementary process. इसमें कुछ judgments का reference है, ना? Already को बोलिएगा या तो record पर होगा, इससे लगा हुआ, है ना? या फिर उसका record बना देगा, read का orders है. Next Wednesday holiday है, Thursday को.
Item 22. WPL.
DFD कर लेंगे. Second half में करेंगे. तब तक हो सकता है सुन लें. चलिए.
Item 22. WPL 5095 of 2012.
Yes.
I'm responding here.
Yes. Who is for the petitioner?
My lord, here I find the name of the late Honorable Mr. Kailash Prasad Dev. It's not there in the first list. I'm seeing the
But
case.
there are many other advocates.
Yes, some other names, Gaurav, Ashish Kumar, I don't know.
We know each one of them. You don't know them.
I know Ashish, I don't know which Gaurav.
Gaurav, yes.
I don't know which Gaurav is. This case is being taken up after a long time, after 2019.
Ashish has perhaps left practice, I'm not sure. Gaurav is there. क्या matter?
My lord, the petitioner has alleged that he was illegally terminated from service. But he was forced to resign and the forced resignation was taken from him and his claim has been rejected by the labor.
BS case.
Well, he was a doctor, so shops in his country. Doctor employed at Tata Main Hospital.
Tata Main, yes,
TMH,
it is covered by shops and stuff,
Lot.
by virtue of Jharkhand toxicology.
Well,
Petitioner को आ नहीं गया. किसी को amicus appoint कर दो. लाई जर्नलिस्ट कीजिए. Will appoint an amicus.
and when the list is taken out, Your Lordship, the case where Your Lordship had directed me to make corrections, I find that in the first case, this particular workman is not a party.
Okay.
So while dictating order, Your Lordship.
I take care. WPL number 5092 of 2012. Nobody appears on behalf of the petitioner on account of in spite of repeated calls. Counsel for the respondent is present. Faced with this situation, this court finds it proper to appoint an amicus for the purposes of disposal of this case who can assist the suit from the side of the petitioner. Accordingly, Mrs. Prema Hindumana, इसका enrollment number details is hereby appointed as amicus to represent the petitioner. Office is directed to, whose details are as under. Office is directed to forward a copy of the entire records of this. A soft copy, you will provide copy, do you have a copy?
Well, it's the old case and I was not involved in filing it. I'll have to get the whole thing typed.
Sorry, why do you need to have to get it typed? You
Well,
don't have a
I was
copy.
not involved in filing this case. I have myself been engaged later.
You must be having a copy of the record.
I have the copy. I can give them a Xerox copy. I can't give a soft copy.
Only Xerox copy.
A
You
Xerox
provide
copy.
it to
No issues with that. I thought Your Lordship said
The
soft
counsel
copy.
for the state respondent is directed to provide a photocopy of the records to MS Prerna Hindumana. oppose this case for final disposal on 11th of December.
We'll keep it also. 12th, Your Lordship, 11th, I'm already quite a few
12th of December. 12th December.
Right.
Yes.
Next item also, that's 23. Which I am the petitioner, but also that's we have already complied that order. I have filed the supplementary of 14/8/2019. We have heard the statement that we have already complied that order by depositing that amount which was awarded by the Labour Commissioner Central.
So there is nothing is surviving?
Nothing, but the difficulty also that the respondent is not appearing in spite of the.
You see, just a moment. You have challenged this order.
Yes.
Now, since you have complied with
Yes.
the award, nothing survives.
Nothing survives.
Like if he has, he will go for execution, whatever. Why should we make an observation?
Certainly, Lord. That's that.
Okay. W, call करिए sir.
Item 23 WPL 6861 of 2012.
तो जब आपने कंप्लाई कर दिया इसको तो एडमिट कैसे हुआ 1321
That was the condition for admission. That was the condition, and we have already deposited that amount, and the notices were issued to the other side respondent, the workmen's amount. But in spite of that, repeated notices that they are not appearing.
Then since you have deposited the amount, should I say that you have no surviving grievance against the impugned award, right? WPL number 6861 of 2012. Learned counsel for the petitioner is present. Nobody appears on behalf of the respondents. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner does not want to pursue the present case, and the order impugned in the present case has already been complied by
depositing
the amount
through 10 DDs
before the concerned authority. He has also submitted that in case the workman has surviving grievance, they may proceed in accordance with law. Considering the aforesaid submissions, this petition is dismissed as not pressed.
disposed of. That's not the observation made.
Dismissed as not pressed. Interim order if any stands vacated.
Disposal भी हो ही सकता है, इसमें तो दिक्कत कुछ नहीं. We have, since we have complied that order, therefore I am saying that it should be buried with हम लोग जान लेंगे.
Considering the aforesaid submissions, this writ petition is disposed of, and disposed of as such, it is made clear that it will be open to the respondent to take steps in connection with the execution of the order impugned in the present case in accordance with law.